We are going to be covering all the documents that have been dropping in the Kouri Richins case. You guys haven't seen our previous videos that we've been covering on this case. We do have a Kouri Richins playlist if you need to be caught up. But we've been trying to cover all these court documents that have been dropping left and right. You know, we have the Coburger case. Now we got Kouri Richins. And I'm just honestly just playing catch up right now. And then we have all these trials that are starting soon. For example, Lori Vallow Daybell, jury selection. Seems like they were able to get a jury selected within the first day or two. It's comprised of, I think, 13 men and maybe 3 women, if I remember correctly. And then they'll have 12 people ultimately deciding Lori's fate. And they'll have, like, I don't know, a couple left over for alternates. And then we have Karen Reed. Karen Reed is currently in jury selection as well. And I think her trial is slated to maybe start sometime the end of this month. But we will be live streaming Lori Vallow's opening statements next Monday. Again, she is representing herself, and I just think it's going to be a fucking shit show. From what I've heard, what I've seen so far, representing yourself when you don't really have any legal experience, when you're kind of batshit crazy, I don't know, it just doesn't really sound like a really good recipe, but we'll see what happens then. Hi, Shaniqua. Hi, Angel. How are you doing today? Hello, hello. No, what was I going to say? Kind of lost my train of thought about talking about Lori Vallow. Karen Reed's having her trial. Okay, I think that's about it. Yeah. Okay. I like lost my train of thought. I feel like I had more to say. All right, y'all. Well, that's what happens when you eat like a half breakfast. I think I need more food in my digestive system. So today we're going to be covering Kouri Richins. And Kouri Richins, well, there's been a lot of documents that's been dropping. And we're, learning more and more about what the defense's strategy is going to be, some evidence that they might present, and then maybe some strategy from the state as well. For Kouri Richins' case, we have a lot of information about this. It's not like the Coburger case where we're getting like little tiny driplets here and there. With the Kouri Richins case, man, there is a lot going on with her. A lot of things that I feel like she's going down the checklist of all the things that you're not supposed to do when accused of committing a crime. And it's going to be really tough for her to really explain some of the things to the jury. I do wonder if she's going to testify. I feel like she has to testify. She's going to have to testify. She's going to have to talk about the night that her husband died. Again, she's accused of murdering her husband by poisoning him with fentanyl. She told law enforcement, she told the medical examiner, she told, I think, friends and family that her husband doesn't do illicit drugs. I don't know how the fentanyl fucking got there. He just does like 8 THC gummies once in a while. However, the medical examiner found that there was like 3 times the lethal dose of fentanyl in his system. So Kouri Richins is being accused of poisoning her husband. Now, she wasn't arrested until about a year later. What's interesting about Kouri Richins is that she wrote a children's book to help her 3 sons grieve about their father who passed away. And she went on this like TV station, talked about her book and talked about how, how the sons were like sad, and then the dad and all that stuff. And then like afterwards, when she appeared on TV, I think the TV station got a tip or like an email from someone saying like, hey, that woman is accused of possibly poisoning her husband. And then she ultimately ended up getting arrested, I think like a month or 2 or something afterwards. So this is a wild case because there's just been so much. There's been accusations of previously trying to poison him before on Valentine's Day with the egg sandwich. There's her running her business to shambles. Apparently, she was stealing money from her husband to fuel her business. And then her business was just not doing well. And she was like borrowing money. And then she was moving all the money around. The state is accusing her of scamming her best friend, like taking the money from the best friend for a down deposit for a house and then using it to pay into her business. Possibly, even scamming her mom. It's a whole fucking mess. It's almost like Alec Murdoch level. It's a whole mess. There's like schemes here and there, all these accusations. And then also on top of it, the state also says that Kouri Richins was having an affair with a man for who knows how long. Apparently it could be 6 years because I think the guy said something about being with Kouri for 6 years and Kouri Richins didn't correct him. But yeah, these are what the documents are going to reveal, what the state thinks about Kouri Richins and some of their theories about Kouri Richins. It's crazy. It is wild. When was this? Oh, is it Shinjan in your profile picture? Oh, I love your profile picture. So good. This was back in like 2022 when she was, I think, no, I think she was arrested in 2023. The poisoning, I think, happened in 2022. Oh, how the boys will feel after they grow up and how much they will literally hate her. And then there's a lot of family drama happening with her and her deceased husband's family. She wanted to have custody of the kids, or she wanted her side of the family to have custody of the kids, but I don't think they do. I think the husband side of the family, I think they have custody of the three kids. But man, yeah, I don't know. I just feel so bad for the children. Even when we're looking at like the Adelson family. If you guys don't know about that case, the Adelson family, that's a whole fucking mess too. Where you have these two young boys, their father was murdered, when they were like what, I don't know, like 3, 4 years old. And the people that are accused of being involved in that are people in their immediate family, grandmother, uncle, mom. We'll see. Mom hasn't had a trial yet. Mom hasn't been arrested or anything yet. So maybe mom isn't involved. But right now, grandma's on trial. And, it's going to be, it's just so sad. I can't imagine being these kids growing up. Hi, Tam. How are you doing today? How's it going? But let's get into these court documents because we learn so much information. There's been a lot of motions denied for the defendant, and there's a lot of setbacks. However, the defense did get some stuff granted, so we'll go over all the stuff so far. All right, so I anticipate today's stream to be, I can't do Lori, speed. It's not going to be under an hour. It'll probably, I think, be around like maybe 2 hours. So, you guys, have me on, have me in the background, do your chores, or you guys can read along with me. I'll have it zoomed up for you guys if you guys want to read along, and I will mostly read it. I think some stuff might be redundant, so I might skim through. So let's start with the ruling and order denying defendant's motion to suppress electronic data. So this is from the judge. Defendant Kouri Richins moved to suppress electronic data seized from her cell phones because the underlying search warrants lack particularity for the defense. Because the warrants in question are sufficiently particular, says the court, the motion to suppress is denied without prejudice. Now let's look at the dates here. Between May 8, 2023, January 23rd, 2025. I can't believe how time is going by so fast. Isn't it crazy? We're in 2025. Detectives secured 4 search warrants to search the defendant's cell phones for evidence of the crime of aggravated murder. Although most of the alleged facts in the support of probable cause to search the phones are identical, there are some unique elements. Despite the unique elements, each of the warrants authorize the search of the same 11 categories of evidence. 1. Electronic documents. 2. Email, instant messaging, text messages. Number 3. Personal communications. 4. Internet history. We got some good internet history searchers in this case too. Oh my goodness. Number 5, personal and business schedules. Number 6, photographs, images, and video. 7, contacts lists and phone numbers. 8, call history. 9, GPS location history. 10, social media activity and messages. And 11, all other digital activity stored on the device. Now, if you guys remember, Kouri Richins had her phone taken, and they found that she deleted a lot of stuff on her phone. Apparently, she deleted a lot of communications. I think it was like 2 months leading up to Eric Richens' death, and then possibly it was like 2 weeks after Eric Richens' death. It's like, a lot of deletions happening here. Wonder what's going on. And then subsequently, she did end up getting a second phone as a replacement for the first phone. And that second phone was ultimately taken. And in that second phone, we have some very possibly incriminating searches, like I think it was like, how long does it take to get like the insurance payout? Prisons for rich people, just some of the stuff like that. Now, defendant Kouri Richins, did she plan the book or was that a cash grab? I don't know. I have no idea. We will find out, I guess, more. Hopefully, maybe. I mean, we even have her diary. Isn't that crazy? She had a diary talking about or writing about the night that Eric Richens died. Of course, she wanted to have that diary, suppressed, but the court date denied that. We're going to jump to that quickly soon. Defendant argues that the authorization to search the 11 categories of evidence is overbroad when compared to the specific evidence sought in the affidavits. According to the defendant, law enforcement extracted all digital data from the phones in response to the warrants, conducting a comprehensive search in violation of defendant's expectation of the right to privacy. A search warrant's objective is to ensure that law enforcement seizes items that are within the scope of probable cause without seizing items that are outside the scope of the crime being investigated. However, how broad a warrant must be necessarily depends on the circumstances and the nature of the activity under investigation. Electronic devices, which can now be used to store millions of files and data, presents an emerging challenge for judges when evaluating the particularity of a search warrant. On the one hand, personal devices are ubiquitous and contain a vast array of a person's private affairs. Yeah, your phone probably has almost fucking everything, at least mine does. On the other hand, they can also be used by criminals to hide, mislabel, manipulate files to conceal criminal activities, particularly in cases involving contraband, such as drugs, in which cases the more generic descriptions are allowed. Because of the competing concerns here between individual data privacy and concerns over concealed information, federal courts have required that warrants for computer searches affirmatively limit the search to evidence of specific federal crimes or specific types of material. So, what they are going to be focusing on is going to be evidence of crime of aggravated murder. Oh, God, I don't want to highlight the whole thing. The limitation is meaningful as it eliminates the possibility of warrants being construed as a general warrant, whereby administrative officers determine what is and what is not to be seized, and focuses on the scope of the warrant on the evidence of the elements of the crime under investigation. Moreover, law enforcement, they showed probable cause for the administration of poison as an aggravating circumstances. This element requires the government to investigate whether Kouri Richins sought, secured, administered fentanyl to Eric Richens, and such an investigation reasonably requires more generic descriptions of the evidence sought. Homicide by the administration of fentanyl ostensibly takes planning, requires multiple steps over time. Evidence this crime is not necessarily limited to a short time before or after the alleged victim's death, especially when investigating the relationship between the defendant and the potential sources of fentanyl. Now, remember, it is alleged that Kouri Richins got fentanyl from her, I think it was like from her housemaid, who was labeled as CL. And CL did do a deal with the state where basically they spilled everything because there was something other shit that CL was like getting in trouble for. Relevant screenshots, photographs, text conversations, GPS data, and other metadata over various applications could be saved in a wide array of files on the phone. And internet history over time could show the gathering information on how to prepare for and complete the crime. Law enforcement also had probable cause to seek the evidence of defendant's consciousness of guilt and evidence regarding her credibility, including whether Kouri deleted any items from her phone at relevant times and whether the data recorded by her phone is consistent with her description of what occurred the night of the alleged victim's death. Now, again, the state has said that Kouri Richins said that XYZ happened. However, when we got her phone data, it seems like that wasn't true. It seems like she might have waited a bit before she called 911 because they were able to record her steps, what she was doing during that time, if she was awake or not. Kouri said that after, I think like her and Eric were like heading to bed, she decided to not sleep in the bed because one of her children was having night terrors or something like that. So she went to the child's room and like slept with the kid. And then after a couple of hours, she decided to go back to her bedroom with Eric Richens, her husband. But when she came back, she realized that Eric was not breathing or something. And it seems like something had happened to him. And then she called 911 afterwards. But when they looked at her phone, they were like, this doesn't seem very consistent to what you told law enforcement. Back to the court doc. Given the complexity of the crime of aggravated murder involving the administration of fentanyl, the court concludes the warrants in question were sufficiently particular to satisfy both the federal and Utah constitutions. Defendant has not identified any specific evidence or information that law enforcement seized outside the scope of probable cause when searching the extractions of defendant's phone. However, if defendant determines law enforcement exceeded the scope of the approved search when reviewing the extractions of the defendant's devices, defendant may file a subsequent motion to suppress. But for now, it is denied without prejudice. Next court doc, we got a ruling and order denying a motion to compel good cause disclosures. This is from docket 802. Oh, this is from her mother's cell phone. Okay. So here's what the state wants. The state of Utah wants to exclude from trial material that Kouri's formal counsel, so that would have been Sky Lazaro, downloaded from Lisa Darden's cell phone. Lisa Darden is Kouri Richins' mother. For an order that current defense counsel provide a copy of the material to hold the court to hold in escrow and to have the court reserve ruling on spoliation claims. So back in summer 2023, the parties agreed that defendant's former counsel copied screenshots of selected text messages between the victim, Eric Richens, and the mother, Lisa Darden. Former counsel provided the screenshots to current counsel along with screenshots of a note on Lisa Darden's phone and 2 photographs. In its motion, the state moved to compel the screenshots made by the former counsel. Current counsel invoked work product privilege as former counsel's decision regarding the screenshots to take and preserve would reveal her thoughts and impressions about the defense strategy, and because the screenshots were taken and preserved in anticipation of litigation. However, the state does not challenge the defendant's assertion of work product protection. Rather, the state seeks to have the screenshots excluded from trial completely. Now, the court is saying that, well, the state's motion to exclude is premature because they don't know whether or not they, the defendant, they haven't made the determination if they're actually going to use those screenshots in the trial. So, there's also a state's request to hold the court, for the court to hold a copy of the screenshot material in escrow. However, the court says, well, the defense counsel, they have a duty to preserve evidence anyway, so they should be doing it as, you know, because they should be doing it already to comply with discovery obligations. So there's that. Oh, wait, I will save this. Yes. All right, next one. Ruling an order granting in part and denying in the motion to suppress letter. So this is going to talk about the walk the dog letter. Walk the dog letter, I honestly think the dog is referred to as the brother. It's like treat the dog or treat the brother like a dog, put a leash on him and get him to do what I want him to do. And it was the assertion that Kouri Richins was trying to witness tamper. Kouri Richins was trying to get her brother to falsely testify about where Eric Richens get his drugs in Mexico, blah, blah, blah. So Kouri Richins moves to suppress the document known as Walk the Dog letter for 2 reasons. 1, Kouri Richins asserts the letter is protected by attorney-client privilege. Number 2, Kouri Richins asserts the letter is protected from disclosure under attorney work product doctrine. Work product and attorney-client protected materials are not discoverable in criminal cases and by extension are not admissible at trial unless the protections are waived. Now, going back to September 14, 2023, jail staff searched the defendant's cell and found the 6-page walk the dog letter among her things. The parties disagree whether the document was found in an envelope labeled Sky Lazaro, the name of the defendant's formal counsel, and whether it was found among the LSAT materials. So the defense is saying that no, it was in an envelope labeled Sky Lazaro. It was supposed to be for her attorney at that time. The state, I think the jail staff said that, like, no, we actually found it amongst her, like, LSAT, like, materials book or something like that. So there's a disagreement there. The video of the search of the defendant's cell does not definitively reveal where the document was found. Yes, there was a video that we did watch together, and you can't really see much. You could see them searching through, like, the bunk bed and searching through the documents, stuff like that, but you can't really see a zoom in of, like, okay, what document came from where. Because the exact place the defendant kept the walk the dog letter is not determinative to the court's ruling, the court need not resolve this factual discrepancy. So the court's like, we don't care. Number 1. The walk the dog letter is not privilege, attorney-client privilege. Now, we covered this, I think, in a different video, or was it a different live stream? It could have been a video, maybe. So remember in the walk the dog letter, Sky Lazaro, the attorney, is not addressed in the letter, nor is Sky Lazaro spoken to. Sky Lazaro was not addressed in the letter. And then also when they referred to Sky Lazaro, it was in 3rd person. So it was obvious that the recipient of the letter was the mother, Kouri's mother, not Sky Lazaro. And that was something that was argued by the state. And I believe the court also agrees with that as well. Number 2, parts of the walk the dog letter are protected under the work product doctrine. The work product doctrine protects an attorney's mental impressions, conclusions, opinions, or legal theories. 5 sentences in the Walk the Dog letter reveal the mental impressions, opinions, legal theories that defendant's former counsel, Sky Lazaro, formed during her representation of the defendant in this matter. So, for example, here are some of the sentences. Page 1, beginning with Sky is saying, and going through the phrase, would stay at, and page 3, beginning with Sky has to make the connection, She can use that as a connection. Because these portions of Walk the Dog letter memorialize prior counsel's defense strategy, they are, however, protected under work product doctrine. So these can be excluded from the evidence, or maybe like redacted, I guess. Now, the court says this. The remainder of the Walk the Dog letter, however, does not reflect the mental impressions, conclusions, opinions, or legal theories of the defendant's attorneys. Rather, the remainder of the Walk the Dog letter reflects defendant's independent thinking, separate apart from anything her attorney said to her or directed her to write. Accordingly, the remainder of the Walk the Dog letter is not protected by work product doctrine. And, when the jury, when they get to see parts of that letter, they're going to be like, well, does it look like she is trying to get her brother to say that this is where Eric got fentanyl? And is she trying to make her brother lie because it shows that she has a consciousness of guilt? Otherwise, why lie? Why go through all this and try to get your brother to come up with a story if you didn't do anything wrong? Number 3, to the extent the work product doctrine applies, defendant has not waived the protection. The state asserts that even if the letter contained protected material, defendant has waived any protection for 2 reasons. Number 1, defendant used the Walk the Dog letter as an exhibit in a motion. And 2, the defendant wrote the letter to engage in a crime. Now, just to mention this, they did not charge her with witness tampering. There's the state is saying that she was trying to engage in a crime, but they never charged her with it. Here's what the court says. First, there's no credible evidence in the record that the defendant has ever shared the Walk the Dog letter with anyone prior to it being seized by the state, subsequently disclosed by the state as docket entry 214. Notwithstanding the content of the letter shows it was intended for the defendant's mother, there is no indication in the record that it was ever sent or otherwise disclosed. Second, defendant's actions after the state disclosed the letter in a public filing do not constitute a ratification of the state's actions or a failure to take reasonable precautions against inadvertent disclosure. After the letter was filed in the court's docket as a public document and was widely discussed in the media, defendant had no duty to make a futile attempt to claw back the document. Further, although defendant attached the letter as an exhibit to a motion, the subject of that motion was to seek sanctions against the state for disclosing the letter in the first instance. This conduct does not constitute a waiver of work product protection. Third, because the court has determined the letter does not constitute a privilege attorney-client privilege, the state's argument regarding other crime fraud exception of the Rule 504D1 is moot. So here's what the court has ordered. Again, only parts of it's not even parts, it's like a couple sentences that are going to be redacted from the Walk the Dog letter, but everything else is fair game. And you know what? The rest of the letter really it makes Kouri Richins look really fucking bad. So I would say that's a major loss for her. Next one, ruling. Let's see what we got here. Ruling an order granting in part and denying in part of defendant's motion to suppress statements and evidence. So we had a court hearing about this was it over a month ago? I think it was about a month ago, a couple weeks ago. So there was quite a few things that she wanted to have suppressed. It was statements that she made to these 2 detectives while they were at her house on April 13, 2022. There was a white iPhone that she had that police took away. And then this is the one where police asked her for the passcode and she gave it to them. But when we get more context, the reason why police asked her for the phone's passcode was because she wanted to grab contacts out of her phone. And they're like, okay, well, what's your passcode? And she gave it to them. And, they had the passcode to access her phone. Number 3, statements she made in an interview to a detective on April 14. This is when the detective came over to her house to introduce himself. And she made statements and she's like, oh no, like these statements, I wasn't Mirandized or I didn't have my attorney present. And then there's the orange notebook, which is purportedly a diary that she was keeping. And I don't know why she kept this diary. Again, she was arrested about a year after Eric died. You know, let's say that she did commit this crime. Why would you keep this notebook? Very strange. Number one, defendant's statements to Detective Woody on April 13, 2022 are protected by the Fifth Amendment. So this is like a win for her. Relevant facts. Now, going back to April 12, 2022. Officers secured a warrant to search Kouri's person and her Willow Court property and seize, among other things, any cell phone. The next day at approximately 9:57 a.m., Detective Maynard observed the defendant leave her Willow Court home in her SUV. Detective Maynard followed defendant's vehicle as she turned a corner. He turned on his emergency lights, initiated a traffic stop. Detective Maynard was wearing a jacket with a law enforcement logo and a visible police badge. Detective Maynard saw through the driver's side window of defendant's SUV that defendant had her phone in her lap. He told defendant to step out of the vehicle and informed her she was being detained. Defendant left her phone and keys in the SUV. He placed the defendant in the front passenger seat of his vehicle while he sat in the driver's seat. She was not handcuffed. Detective Maynard told the defendant she was not arrested, but that she had to sit with him until other officers arrived to explain to her what was happening. Hey, Michael, how are you doing today? They sank her battleship. Hello, hello. After approximately 21 minutes, Detective Woody approached the front passenger side window and told the defendant she wanted to ask some questions. I didn't know Detective Woody was a female officer. I don't remember them testifying on the stand. This entire time I thought it was a guy. Detective Woody explained some of the evidence of the case, including that Eric Richens possibly died of a fentanyl overdose. That is an illicit drug. She asked the defendant questions about how Eric could have obtained it. Oh, okay. This is when she made the statements was like, I think she pretended not to know what fentanyl was. Like fentanyl, what's that? Oh, and I forgot what it was exactly. Eventually, Detective Woody told the defendant, "You're welcome to go back to the home if you want. You can go until we're finished. You can go in until we're finished. Hey, Moondog, how are you doing today?" Let me read the sentence. Eventually, Detective Woody told the defendant, "You're welcome to go back home if you want. Can't go in until we're finished, but you can do whatever you need." The detective then asked, "Do you want to come with me and grab your phone real quick?" Defendant exited Detective Maynard's car, walked with Detective Woody to her SUV. Defendant reached into her SUV, retrieved her phone, and handed it to Detective Woody. The phone was a white iPhone 12 bearing IME number, blah, blah, blah. Detective Woody and defendant then had the following exchange. Woody: "Yeah, like I said, you're welcome to go back to the house, just not in it until we're finished. If you need to go make any phone calls or whatever you need to do, blah, 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 blah." Inaudible. Defendant: "Do you want me to, how can I make phone calls if..." Woody: "Yeah, I just meant like if you have friends or your mom's phone or whatever else." It's like, how is she supposed to make phone calls if you're taking her phone away? Most people don't really have like a house number anymore. Defendant: "Can I write down their numbers?" Back to the document. Detective Woody then handed the phone to Detective Maynard and told the defendant, "And then he'll follow you back, and then you can do that." Defendant got in her SUV alone, drove to the Willow Court home. Detective Maynard drove to the home behind her. Discussion. So, what do we think is going to be considered protected by the Fifth Amendment? Now, I thought it was important that the court mention the detective was wearing a jacket with a law enforcement logo and a visible police badge. So that tells me that if you're someone that's, you're probably going to consider being detained if someone who visibly is law enforcement tells you, "Hey, you're not free to go. You have to come sit in the front seat with me, and we're just going to wait here until they search your house," right? If you were anyone, you probably would think that like, "Oh, fuck, I am detained. I'm not free to go anywhere." Let's go to the discussion. Not a good actress? Who's not a good actress? Oh, who? Kouri? Yeah, Moon, I hope you're having a good, oh gosh, today's Thursday already. Ooh, I hope you're having a good week, Moon. Discussion. Defendant argues her statements to the detectives while she was detained in Detective Maynard's car should be suppressed under Fifth Amendment because the officers interrogated her without first informing her of her Miranda rights. So again, Miranda rights, like you have a right to be silent, blah, 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 anything that can be used against you, blah, blah, blah. The Fifth Amendment provides that no person should be compelled in any criminal case to be a witness against himself. The right against self-discrimination is protected by excluding from a defendant's criminal trial any incriminating statements the defendant made to police officers while under custodial interrogation if the officers did not give a Miranda warning. So obviously the court's going to say that, well, it seems like Kouri Richins was under a custodial interrogation and she wasn't free to go. Sarah Adams, hello. How are you doing today? Wait, why does it say became a sponsor? Is that a Stream Elements glitch? Sarah Adams, thank you so much for joining the membership. Hello, hello. Welcome, welcome. Enjoy your emails. Thank you so much for your support. And yeah, I hope you're doing well today. All right, so Fifth Amendment, you have a right to not make incriminating statements to police officers if you're under custodial interrogation and if they not give a Miranda warning. Whether an individual in his custody is an objective analysis that is informed by the reasonable inquiry, namely whether or not a reasonable person in the suspect's position would have felt free to leave. The court must examine all the circumstances surrounding the interrogation, including any circumstances that would have affected how a reasonable person in the suspect's position would perceive his or her freedom to leave. Whether questioning is considered an interrogation requires the court to examine if the officers engaged in either express questioning or its functional equivalent, and whether there were any words or actions on the part of the officers that they should have known were reasonably likely to elicit a incriminating response. So who's going to get in trouble? Well, I don't think they're going to get in trouble, but who's sort of in trouble here? I will assume Detective Woody, right? Detective Woody asking these questions. Now these questions can be used in the courtroom. Defendant's detention was accompanied by some indicia of arrest. Detective Maynard initiated defendant's custody by turning on his emergency lights and pulling the defendant over. He was wearing a jacket with a law enforcement logo and was carrying a badge. He ordered her out of the car, indicated that she was not free to leave, had her sit in his vehicle next to him. She was detained for over 20 minutes. When Detective Woody arrived, the detective stood outside the passenger side window, blocking defendant in the car. These factors, taken together, support the conclusion that a reasonable person in the defendant's position would not have believed that she was free to leave until told to do so by the officers. Detective Woody told defendant her husband may have died from fentanyl overdose and asked questions about how Eric Richens may have obtained and ingested fentanyl. The officers should have known that these questions, even if asked for the purpose of safely executing the warrant, were likely to elicit incriminating responses from the defendant. Now, based upon these findings, the court concludes the defendant was subject to a custodial interrogation from the time Detective Woody began speaking to her until the moment Detective Woody told the defendant she was free to leave. Because the officer did not read the defendant's her Miranda rights, any statements the defendant made during this time, from the time Detective Woody began speaking to her until the moment Detective Woody told the defendant she was free to leave, are suppressed under Fifth Amendment. However, that's part of the day. Now, the rest of the day, it's not going to be protected under Fifth or Fourth Amendment because at some point she was told that she was free to leave. Let me get a sip of water. Number 2, officers did not violate the Fourth or Fifth Amendments when securing the iPhone and asking for the password to the iPhone. Additional relevant facts. When the defendant reached her Willicourt home, she pulled her vehicle partially into the garage. Approximately 10 officers were at the home executing the search warrant. Defendant was not given any instructions from any officers when she reached the house. Detective Maynard asked defendant for her passcode, which she provided. Man, don't be giving law enforcement your passcode to your phone, man. Detective Maynard then provided defendant with phone numbers of her contacts on her phone. I mean, they have the technology to get in there anyways, but like, dude, just to give their, law enforcement your passcode, like. In his police report, Detective Maynard wrote that he released Kouri from any custody and went to the home. Detective Maynard testified credibly that his word of the use of the word custody was a poor choice, and it did not indicate that he believed defendant was in custody when she was at home. He had no further contact with the defendant on that day. Later that day, officers secured a search warrant for the defendant's car, including her SUV. The Regional Computer Forensic Laboratory extracted defendant's cell phone using her passcode pursuant to the warrant issued on April 20th, 2022. Yeah, you're just making their job easier for them, The SCSO was unable to access the extraction. In December 2022, the SCSO had the technological capability to extract the cell phone without using the passcode. Officers executed 3 more search warrants of the phone for evidence of the crime of aggravated murder. The phone was extracted twice by using the passcode provided by the defendant and once without using the passcode. Discussion. Defendant argues that her iPhone 12 should be suppressed under both the Fourth and the Fifth Amendments. Suppression is not warranted under Fourth Amendment. The court explains why. The state has shown by preponderance of evidence that suppression of the defendant's iPhone 12 is not warranted under Fourth Amendment for 3 reasons. 1. Officers had a warrant to search the defendant's person for the cell phone. Number 2. Defendant consented to the seizure of her phone. Number 3. The phone could have been seized under the automobile exception to the warrant requirement. I wonder, so if they had a search warrant for the phone, and then she says, no, I don't want you to take it, I mean, she would have to give them anyways because they had a warrant for it. I guess a little confused about number 2. I guess, did she consent to the seizure of the phone when she gave them the passcode? Does that count? Hi, Go Lucky. How are you doing today? What's up? Oh my gosh. New season of Marvel Rivals. I'm excited. Although I don't know if I'm gonna be super excited for the skins though. I saw the skins and they look very like gala dressy. Like I'm like, eh. Brian Bradley, hello. How's it going today? Brian Bradley, thank you so much for the 999. Thank you so much for the super chat. I hope you're doing well. How is everything? Guys, I'm curious. What cases are you guys following right now? I feel like there's so much happening in the true crime world that I don't know how you guys have time to follow these cases. I don't know. I feel like I knew April was gonna be super fucking busy. Like April's gonna be busy, May, June, possibly July. Yeah, because Donna Adelson's gonna be happening, Kouri Richins. Like, oh my god, I feel like everything's just happening all at the same time and it's just all squeezed in together. And then when summer's over, we're gonna have the Idaho 4 murders if it doesn't get delayed. Whew, lots of stuff happening this year. Okay, so the detectives had a warrant to seize any cell phones from a defendant's person. When Detective Maynard first stopped defendant in her car, he saw she was holding her cell phone in her lap. Notably, Detective Maynard could have taken the phone from the defendant's person at that moment. Although Detective Maynard separated the defendant from her phone for a period of time and waited until Detective Woody arrived to execute the warrant, the phone was still seized from the defendant's person. The defendant herself reached into the car at the request of Detective Woody and handed the phone to the detective. Based upon these facts, the court concludes the phone was seized pursuant to the original warrant executed on April 13, 2022. Now, to the extent asking the defendant to retrieve the phone from her car and hand it to the Detective Woody is considered a warrantless search of the defendant's vehicle, defendant consented to the search. Yeah, but I don't think she knew that she consented to the search. Consent is not voluntary if it is obtained as a product of duress or coercion or express or implied. When evaluating whether a person consents to a search, the court must consider the totality of the circumstances, including 1. The absence of a claim of authority to search by the officers. 2. The absence of an exhibition of force by the officers. 3. A mere request to search. 4. Cooperation by the owner of the property. 5. The absence of deception or the trick on the part of the officer. Detective Woody explained that the officers had the authority to search the defendant's persons and her home for cell phones, which implies they also had the authority to search the defendant's car. But given the totality of the circumstances, this implication does not show defendant was under duress or coercion when she handed Detective Woody her phone. The officers did not exhibit any show of force. They did not demand the phone. They did not even try to trick or deceive the defendant. The defendant exhibited a willingness to cooperate with the officers. She did not protest providing her phone, but immediately retrieved it from her vehicle for Detective Woody. Based upon these facts, the court concludes she consented to the search of her car. Oh man, I'm sure she sure as hell didn't want to. New Lexi info, Lexi Treviso. No, there's been nothing with Alexi Treviso. I checked a couple days ago. The only thing I've seen so far is some court documents that were uploaded back in December. Still waiting for the Supreme Court decision. Yeah. Supreme Court decision. But I think Alexi Treviso is what? She's probably in her sophomore year now of university. And then I think this upcoming fall she'll probably be a junior. Wow. Crazy how time flies. Crazy. But yeah, I have not heard any new information from Alexi Treviso case. We're just waiting for the Supreme Court to see if they're going to allow all that evidence to be back in. There was a lot of stuff that the trial judge excluded. And yeah, it would be pretty detrimental for the state's case. Even if the defendant did not consent to the search of her vehicle, Detective Woody seized the phone pursuant to the automobile exception to the warrant requirement of the Fourth Amendment. Under that exception, if a car is readily mobile and probable cause exists to believe that it contains contraband, the Fourth Amendment permits police to search the vehicle without more. Common items with legal uses can be defined as contraband as long as officers had probable cause to believe that the items reasonably indicate a relation to a criminal activity or are useful as the evidence of a crime. At the time Detective Woody released the defendant from custody, defendant's cell phone was in her SUV. The officers knew the phone was in the SUV because Detective Woody had observed it in her lap when he first pulled her over. The officers had probable cause to believe the cell phone may contain information about the aggravated murder of Eric Richens and specifically about the purchase and distribution of fentanyl, an illegal substance. Had they not seized the phone before the defendant entered her vehicle, they could have risked losing possible evidence of criminal activity. Therefore, the automobile exception to the warrant requirement authorized the seizure of her phone. Suppression is not warranted under the Fifth Amendment. So we covered the Fourth Amendment, now we're moving on to the Fifth Amendment. Defendant argues the iPhone should be suppressed because the officers did not read the defendant her Miranda rights before asking for her phone or asking for her passcode. Because the defendant was not in custody at the time officers asked for her phone and her passcode, there is no Fifth Amendment violation. And even if there was a violation, the contents of the defendant's phone were inevitably discovered by alternative means. Based on the totality of the circumstances, the court concludes the defendant was not in custody at the time Detective Woody asked the defendant to retrieve her phone from their SUV and when Detective Maynard asked for the defendant's passcode. Before Detective Woody asked the defendant for her phone, Detective Woody indicated to the defendant that she was free to do whatever you want. She was let out of Detective Maynard's car and was allowed to walk back to her vehicle. At that moment, a reasonable person in Kouri's position would not have believed her freedom of movement was curtailed in any way. She was no longer in custody. After providing the phone to Detective Woody, defendant got back into her car where she could have driven anywhere she wanted. But imagine if she got back in her car and just like dipped the fuck out. I don't know. I think they would have been like, should we go after her? Like, what the fuck? She chose to return to her home, where Detective Maynard asked for her passcode. Although there were many officers at the defendant's home conducting a search, no officers gave her any commands beyond not going into the house. She was not told to stay in a certain place. She could roam freely and leave if she wanted to do so. Because the defendant was not in custody at the time, both questions were asked. She was not an inherently compelling circumstance that would require the suppression of evidence under the Fifth Amendment. I honestly just think Kouri Richins didn't know her rights, and she was like, oh, they want my phone. Okay, let me give them the phone. And then, oh, I should probably stay around the house. I probably shouldn't leave anywhere. Even though they were like, yeah, you're free to go wherever you want. She was probably like, am I really, though? Even if the defendant was in custody at the moment Detective Woody asked for the phone, the detective's question asked for an act of production and not a testimonial communication that would require suppression under Fifth Amendment. Communication is testimonial if the government compels an individual to use the contents of his own mind to explicitly or implicitly communicate some statement of facts. The only information the defendant conveyed by handing her phone to Detective Woody is that the phone belonged to the defendant. But this information is a foregone conclusion, which does not require suppression. And even if the defendant was in custody at the time Detective Maynard asked for the passcode, the extraction of her phone was inevitable. The government has the ability to extract the phone without the passcode as early as December 2022. Although the government used the passcode to conduct 2 later extractions, they possess the technological capability to access the phone without using the passcode at the time those extractions were completed. Did Sarah Boone also give the passcode to her phone to law enforcement as well? I feel like I'm getting like some sort of a memory. I don't know. I feel like we've done this before, kind of like a deja vu. Remember, there was like something with like Sarah Boone on her phone and like Detective Capsule. I think she also gave her passcode to Detective Capsule. Rosie, Lori Valodebo. Yep. Opening statements next Monday. Plan on watching that. Koberger case when you see the witness's testimony. Hey, Sean. How are you doing today? Oh, Stephen Stearns in Florida. Oh, gosh. That case makes me so sad. So sad. Statements defendants made to Detective O'Driscoll on April 14 are not protected by Fifth or Sixth Amendment. Relevant facts. So, Kouri Richins was visited by Detective Woody and, let's see. Oh, no, actually, sorry. April 14, 2022, Kouri Richins had a formal attorney that contacted Detective Woody and then asserted Kouri Richins' right to counsel. At that time, however, Kouri had not been arrested and there was no judicial proceedings that had been initiated against her. April 14, a different set of detectives, Detective O'Driscoll and Hoffmeyer, contacted Kouri at her home and introduced themselves. I think they were the new detectives that were going to be working on this case. Kouri invited them into her home. What a great idea. Detective O'Driscoll asked if he could hopefully talk to Kouri for a minute. Defendant expressed a willingness to talk and responded, I think this is great. I'm actually glad that you guys are here. Oh, God. The interview was conducted in defendant's living room, approximately 1 hour, 38 minutes. Okay, I didn't know they were talking for that long. Into the interview, Kouri's mother entered the room and was like, are you supposed to be speaking with the detectives? Kouri responded, I have nothing to hide. I'm grateful that they're here. Defendant did not ask the detective to leave or reference her attorney. Yap it away. Defendant seeks to suppress her statements to the officers under 6th and 5th Amendments because the detectives interviewed her without her attorney present and did not read the defendant her Miranda rights. However, the judge has determined that because at the time the state had not initiated any judicial proceedings against Kouri Richins, like they didn't arrest her yet, they were just, just investigating. They just came in to introduce themselves and just ask some questions. Because she hasn't been arrested yet, the 6th Amendment right to counsel had not attached as of April 14, 2023. Accordingly, her statements are not suppressed under the 6th Amendment. Now, the statements are not protected by the 5th Amendment. The right against self-incrimination is protected by excluding from a defendant's criminal trial any incriminating statements the defendant made to police officers while under custodial interrogation, if the officers did not give a Miranda warning. So again, earlier, the judge did determine that when Kouri Richins was getting her house searched and they pulled her out of the car and then they made her sit in the police vehicle and told her she wasn't free to leave, that was considered a custodial interrogation. She was never Mirandized. She made some statements that were incriminating and they can't use that against her. However, the court's going to determine that in this instance, when law enforcement was welcome into her house and she's like talking freely and she's like, I have nothing to hide, that wasn't considered a custodial interrogation. That was something that Kouri Richins willingly and decided to do, talk to law enforcement. Based on the totality of the circumstances, the court concludes the defendant was not in custody on April 14, 2023. Why? She invited the officers into her home. She sat with them in her own living room. Her mother was present for approximately half the interview. She expressed a willingness and even gratitude to be able to speak with the detectives. And although she did not ask the officers to leave, she could have done so at any time. Therefore, she was not subjected to custodial interrogation, and her statements are not protected by 5th Amendment. This is what Kouri argues. Well, the officers were aware that she was represented by counsel and that her attorney had previously invoked her right to counsel. They violated Kouri's 5th Amendment rights by interviewing her regardless of her custody status. Hey, Pita. Hello. Hi, Joe. Oh my God, Joe, not the chicken nuggies. Looks so good. Hi, Storm. How are you guys all doing today? What games have you guys been playing lately? There's some, there's like a new Sims game type of thing called, I forgot what it's called, like Invio. Looks really cool. I feel like there's like so many games that are out right now. Hi, Northwest. Darn, I just saw this. Oh, come catch up. Start from the beginning, catch up, 2 times speed, and then we'll reunite soon. We're going to be going on for quite a bit. There's quite a few documents that I have to cover. Zoe, is that what it's called? Yeah, it looks so cool. But I'm really sad that there's no multiplayer because I want to do some multiplayer shit. Let's play something. Bro, I'm just playing Marvel Rivals. I just play Marvel Rivals. I want to do a game night with my sister and Jan and play some other stuff. But yeah, I've just been playing Marvel Rivals because it's just so easy to just get on and get off. It's not like you have to like set aside some time. You have to plan it. It's just like, oh, let me just hop on real quick. Okay, do 1 round. I'm done. That's it. Repo. Yeah, Jan gave me access to a Steam account. So I downloaded a bunch of games on my computer. Then I had to go out of town. But I downloaded a bunch of games to see if, like for example, I don't know if Repo's going to make me motion sickness. I don't know. You want to start the Ghost of Tsushima? Oh, I think number 2 is coming out, right? Hi, Aaron. How are you doing today? Hello. How's it going, Aaron? Yeah, Northwest. Good luck. 2 times speed. You can do it. Should I download Marvel? I love Marvels. Download Marvels. Play like a couple rounds. Let me know what you think. But I got to Platinum, which I don't think their comp system is correct. There's no way I'm a Platinum player, but maybe it's not as like hard as Overwatch. All right, so Kouri argues that the officers were aware that she was represented by counsel, and because her attorney had previously invoked her right to counsel, they violated Kouri's 5th Amendment rights by interviewing her regardless of her custody status. After a suspect has invoked his or her right to counsel, the suspect is not subject to further interrogation by the authorities until counsel has been made available to him, unless the accused initiates further communications, exchanges, or conversations with the officer. This prevents the officer from taking advantage of the pressures of extended custody by repeatedly attempting to question a suspect who has previously requested counsel until the suspect is badgered into submission. but the invocation of the right to counsel must be inserted inside the context of custodial interrogation. A suspect cannot anticipatorily how do you- anticipatorily invoke the right to counsel and prevent any interrogation by law enforcement officers from ever being initiated. However, or otherwise, the policy behind Edwards and Schatzer have no effect. If an anticipatory invocation of the right to counsel cuts off the ability to conduct an initial interrogation, there will not be any repeated questioning or little reason to believe that a further interview would have the effect of badgering a suspect into submission. Now, because defendant's counsel only anticipatorily asserted her right to counsel outside the context of custodial interrogation, the detectives did not violate defendant's Fifth Amendment rights by interviewing her on April 14. Now, let's talk about the Orange Notebook. The Orange Notebook, the diary. Apparently, we get to know more about the contents of the Orange Notebook in a different court document, and I don't think it's going to mention it in here. But man, why did she keep this Orange Notebook? Why did she keep it for so long? She kept it for over a year and a couple months since Eric has passed. Why keep the notebook? All right. Evidence from the Orange Notebook seized on May 8, 2023 would have been inevitably discovered. Relevant facts. May 8, 2023, detectives executed a search warrant for Kouri's place of residence and seized an Orange Notebook. The warrant did not authorize the seizure of any documents or writing, so the officers should not have taken this Orange Notebook, shouldn't have opened it, whatever. That same day, though, officers executed a second warrant that authorized the seizure of the documents in writing in an effort to cure the warrantless seizure of the notebook under the first warrant. So they knew they fucked up. They're like, oh shit, let's get a second warrant and let's hopefully this gets fixed. May 31, 2023, October 31, 2023, November 6, 2024, December 16, 2024. Officers executed a search warrant at defendant's place of residence. Each authorized the search and seizure of documents and writings that contained evidence of aggravated murder. May 8, 2023. Defendant was arrested and taken into custody. The trustee for the Eric Richens Living Trust took physical control of defendant's place of residence, changed the locks, and installed surveillance cameras. Yeah, because they don't know what that crazy family might be doing. I don't know. From what we've seen so far, it seems like Kouri Richins and her family, they seem a little crazy. The trustee gave access to the home to law enforcement, the trust's private investigator, and temporary guardian of the defendant's 3 children. Other than the children's temporary guardian removing some of the children's belongings and law enforcement, nobody removed any items from the home. So that's going to be very important, especially when the court is making their determination. Discussion. The state concedes that the search and seizure of the Orange Notebook was not authorized by either the warrants issued on May 8, 2023. The state argues seizure of the notebook was inevitable, however, pursuant to the 4 subsequent warrants, beginning with May 31st, 2023. So the state says that, yeah, like the first time was, yeah, we fucked up. We weren't supposed to take that notebook, okay? That was a warrantless seizure. However, we would have discovered that notebook at some point anyways because there were multiple other search warrants that happened. And in those search warrants, they were allowed to seize any writings or documents that contain evidence of aggravated murder. The inevitable discovery doctrine requires the state to show by a preponderance of the evidence that there is some independent basis for a discovery of evidence initially seized without a warrant. Lots of quotes here. We'll skip down here. The state has presented sufficient evidence to support a finding that the Orange Notebook would have been inevitably discovered during any one of the 4 warrants beginning on May 31st, 2023. You're skipping the retrial. You didn't watch the first one. Oh, gosh. Okay. When the mistrial happened, I was like, I don't think I'm going to watch the second one. But then now it's like, okay, well, we got some new experts. We have a new prosecutor. Although Hank Brennan has got some, it's been a little bit rough with Hank Brennan, you know? I liked him a lot initially. I was like, okay, I can listen to Hank Brennan. He doesn't bore me to death. I like how he's got the criminal defense attorney style, you know? But like, bro, Hank Brennan has been, he's been messing up some stuff, man. But, you know, I think I still want to watch it. We got some new experts, new prosecutor, and the defense team. We got some new attorneys on there. Like we got Mr. Alessi on there. And then I think there's a new attorney that recently is part of the Karen Reed case. This attorney was actually an alternate juror for the first murder trial. So I don't think they're going to be like presenting anything or arguing anything. I think maybe they're just there just like maybe like observe and advise. I don't know. But who knows? Maybe we'll see them in action. Not quite sure. Aaron says, to be honest, Kouri sounds like one of those whiny little bitches that I hated in high school. Dude, her fucking emails are the worst. Okay, the emails, the text messages, the LOL, and the emojis. Like, She just seems like a very interesting person. Hey, Melissa. Hello. So happy to have a distraction on Karen Reed. I've been needing to catch up on this case. Oh my God. Yes, there's been so much Karen Reed stuff. I think I'm caught up with the Karen Reed stuff, but I haven't watched the last 2 hearings. Speaking of annoying, ... the Karen Reed case. Oh man. Anyways, so yeah, I don't think I'm gonna stream the Karen Reed case. I think we're gonna listen to opening statements. I might do one of those things where I just watch a Karen Reed case on my own, maybe. I don't know, because there's so many stuff that's gonna be happening at the same time, and I feel like I'd rather cover other stuff. But I definitely am gonna watch a Karen Reed case, maybe on my own, and maybe I'll do like summaries about it. I don't know. It depends. It depends on, there's gonna be a lot of like the same testimonies and stuff, but I don't know. I kind of want to see what's up. It is highly unlikely, so we're going back to the court document. It is highly unlikely that for the illegal seizure, the orange notebook would have been moved, hidden, or removed from the home at any time between May 8 and May 31st, 2023. Very few people had access to the home other than a temporary guardian removing some of the children's possessions. Officers were the only ones to remove any items from the home. Indeed, the fact that the notebook was in a drawer in a home on May 8, 2023, and that the home was supervised and protected by the trustee during that relevant period is strong evidence that the notebook would have been located in the home on May 31st, 2023. Moreover, the 4 subsequent warrants each provided independent legal basis for the officers to seize the orange notebook. The warrants authorized the search and seizure of any documents, writings that contain evidence of ag murder, which involves evidence that Eric Richens was poisoned. This is a complicated crime that involves evidence of seeking, securing, administering an illicit drug. And evidence of seeking, securing an illicit drug implicates the relationship and interactions of defendant and Eric Richens with other individuals who may be sources of the drug. Because there's probable cause to believe that the evidence of this crime would have been found in documents and writings in the home, the search would have been thorough and comprehensive on May 31st, 2023 and thereafter. Therefore, it is highly likely that had the officers not unconstitutionally seized the notebook on May 8, 2023, they would have found it in the same location, seized it pursuant to any of the 4 subsequent warrants. Accordingly, the orange notebook would have been inevitably discovered. So that stays in. I would say, although, I was about to say Karen Reed, what's her name? Kouri Richins, although Kouri Richins had little tiny wins here and there, I think for the most part overall, I think these are just major... Yeah, these are major losses. All right. Next, what do we got here? Oh, this one I'm probably gonna skim through. Okay, so these are some expert, state's expert witnesses. Kouri Richins do not want these experts to testify. Kouri Richins is going to say that the 3 experts are giving opinion testimony and that it's not relevant. Let's focus on number 1, a proffer of Dr. Venino's testimony. So Dr. Venino, Miss Almond's testimony, Mr. Throckmorton, they never met with Eric Richens personally, but they are going to help the jury understand some facts. For example, why would Eric Richens continue to stay with Kouri Richins if he believed that she was trying to poison him? Because it seems like a couple years before Eric Richens' death, they may have went on vacation and Eric Richens may have told family or friends that, hey, I think Kouri tried to poison me, and he was still with her afterwards. It doesn't seem like if you thought someone that you love was trying to poison you, you wouldn't want to stay with him. So it seems like we're going to have some expert testimonies who are going to explain why someone would continue staying in a relationship like this. All right. Dr. Sherry Venino's expert testimony is admissible. So again, these are arguments by the state. Dr. Venino will testify to characteristics of domestic violence victims. So again, this will be Eric Richens, which is a set of principles, without having reviewed any case-specific evidence. Because the defendant only seeks to exclude Dr. Venino's opinion testimony, the court's analysis should end here. So the state is saying, well, this is not just opinion testimony, this is actually expert testimony. It's reliable, it's relevant. The probative value is not substantially outweighed by the unfair prejudice, says the state. Utah courts routinely admit blind expert behavioral characteristic testimony regarding victim behavior. And I think the reason why it's called blind expert behavior characteristics testimony, I think it's because she's never met Eric Richens before. She's never evaluated him. On appeal, such cases typically involve whether testimony regarding child abuse victims' behavior improperly bolsters the victim's credibility. Such testimony does not amount to inadmissible profiling evidence because it does not prove directly the ultimate legal conclusion that a particular victim has been abused and therefore does not improperly invade the province of the jury as a fact finder. Here, the analysis is complicated by improper bolstering issues. Here, the characteristics of DV victims to which Dr. Veneno will testify are grounded in research and generally accepted by DV expert community. Dr. Veneno undeniably possessed knowledge, skill, experience, training, and education in these characteristics. Accordingly, her testimony is reliable. Characteristics of DV victims are relevant because when applied to the facts of this case, they will help a jury understand. For example, I should be highlighting this actually. Highlight. For example, why Eric continues to live with the defendant after she administered fentanyl to him on Valentine's Day 2022. The expert testimony is not profiling evidence because it does not prove directly the ultimate legal conclusion that the defendant committed aggravated murder. Next expert, Dr. Molly Amon. Again, the defendant seeks to exclude Dr. Amon's opinion testimony. However, Ms. Amon will only testify regarding to pathway to violence, a set of principles. Ms. Amon has not reviewed any case-specific evidence and will not offer her opinion. The defendant then seeks to exclude Ms. Amon's testimony as unreliable and irrelevant, and because its probative value is substantially outweighed by unfair prejudice. Again, the same reason for the other expert testimony. Now, what is this expert going to testify about? Pathway to violence may become relevant to rebut any evidence that the defendant may offer of a trait of nonviolence or any assertion that a wife and mother would not unexpectedly murder her husband and father of her 3 children. Its principles, when applied to the facts of this case, would help a jury understand that the defendant developed certain behavioral traits that matriculated over time to the point that she could have committed acts of violence. The pathway to violence may become highly probative because it may be difficult for jurors unfamiliar with to understand the defendant's seemingly counterintuitive behavior. Outside. Any prejudice associated with educating the jury with research-based and generally accepted principles regarding how one can reach the point of committing a violent act is fair impeachment or rebuttal in an aggravated murder case. It is difficult to imagine how unfair prejudice from such education could substantially outweigh the education's probative value, especially when Ms. Amon is not offering an opinion and the defendant is offering a countervailing expert. Accordingly, Ms. Amon's testimony may become admissible under Rule 702 and 401 through 404. Next expert, Matt Throckmorton. What a last name, Throckmorton. Matt Throckmorton expert testimony is admissible. All right, so Matt Throckmorton is an expert who specializes in handwriting styles. This is going to be for the signature forge of, I think the power of attorney. All right, let's see what we got here. Mr. Matt Throckmorton. Forensic document examination rests on 2 well-established principles. 1. That by adulthood, every person establishes their own unique handwriting styles and habits. 2nd, that no 2 persons share the same individual styles and habits develop naturally over a lifetime. Mr. Throckmorton's testimony. Dun, 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 dun. Mr. Throckmorton's testimony. So this talks about his credentials. Mr. Throckmorton will testify that the Eric Richens signature on the True Stage insurance application is a subject of a charged forgery, was probably not authored by Eric Richens, and appears to be a simulated forgery written by someone who is familiar with or has access to Eric Richens' no signature. Has anyone in the chat, and I will not tell on you, I will not report you or judge you, have you guys ever forged someone's signature before? I'm curious. I used to forge my mom's signature all the time, every time when I was late to school. But it was because she wasn't home to sign it. Like, you know, you would wake up late and you're like, fuck, well, I don't want to get detention. So you got to like write out the doctor's note, blah, blah. Or not the doctor's note. You got to write out the like, oh, my child woke up this morning and felt sick, blah, 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 blah. That's why I'm late to school. And my mom would already be at work. And so I would have to forge her fucking signature and be like, yeah, my mom signed this. And it was like a completely shit signature. I didn't even do a good job doing it. The power of attorney needs to be notarized. Oh, wait a second. Yeah, you're right, Northwest. Hold on. How did she get the power attorney thing done then? Or do I have it mixed up? Report cards? Yes. My parents' signature when I forget to have them sign my book reading report. Yeah, I feel like a lot of you guys here know how to do your parents' signatures. I did my mom when I needed my agenda signed when a teacher left a note in there. Now we have the same signature. Love. Yeah, I feel like a lot of us know how to do our mom's signature. One of the parents. Oh man. Throckmorton. Da, 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 da. Although technically I felt like we could have just done any signature because not like our school database was smart enough to keep track of what our parents' signature even looked like to begin with. So you could have just wrote anything. Okay, so Mr. Throckmorton will testify that Eric Richens' signature on the true stage insurance application that is the subject of a charged forgery was probably not altered by Eric Richens. It appears to be a simulated forgery written by someone who's familiar with or has access to Eric Richens' known signature. Wait, am I confused? Because I could have sworn Kouri Richins did like a power of attorney thing. Okay, I think we'll get there soon. That will answer my question. Because you're right, you need to have it notarized. Huh. The testimony is relevant because it makes more probable that the defendant forged a true stage insurance application 33 days before Eric Richens' death. Mr. Throckmorton may testify in rebuttal or impeachment that there is a strong probability that Eric Richens did not author the ER initials on the power of attorney. Wait! Hold on a second. On the power of attorney, the defendant used to obtain a HELOC on his home. I don't know if you need that. Actually, I don't think you need this notarized. Testimony is relevant because it makes more probable that the defendant forged a true stage insurance application 33 days before Eric's death. Throckmorton may testify in rebuttal or impeachment that there is a strong probability that Eric did not author the ER initials on the power of attorney on the defendant used to obtain a HELOC on his home. Do you need to notarize? I would think you would have to notarize it. I don't know what the fuck. There are indications the defendant wrote them. The defendant used the HELOC to fund her business. Crazy. Like, the more we find out about Kouri Richins' business, the more wilder it gets. I thought she started the business on her own and she might have done well initially. And then at some point, she just kind of like over leveraged herself and things just got fucked. But it seems like for her to start the business, she's being accused of stealing money from her husband. Well, sorry, it's not stealing money from her husband because a home is like theirs, but essentially getting a HELOC without, essentially telling the husband on their home and then using it to fund her business. All right. The financial distress of the defendant's business bears upon the pecuniary gain aggravator and is permissible non-character evidence. Throckmorton's testimony will be relevant to rebut an assertion that the defendant was a successful business person because it makes more probable that she operated her business by fraud rather than merit. This testimony should be admissible to impeach the defendant's character for truthfulness if she were to testify. Throckmorton's expert testimony is highly probative because, as discussed below, his ability to identify the genuineness or non-genuineness of question writings far exceeds that of a layperson. Any prejudice associated with Throckmorton's opinion is fair in a forgery case. Any unfair prejudice from arising in his opinion does not substantially outweigh the opinion's probative value. And the defendant, of course, may provide countervailing expert opinion testimony to mitigate any prejudice. Accordingly, Throckmorton's testimony is admissible under Rules 702C and 401 through 404. This talks about how his testimony is also reliable. And then we get into some history lessons. Modern handwriting comparison began at the start of the 20th century. Let's skip through all that. We talk about some studies. And then this is the argument from the state. Save. All right, next one. I don't think. Oh, this is where the defense was saying that the detective lied on the stand, that his testimony was like not consistent or something. Ruling regarding motion to compel disclosure of Giglio material and ordering in-camera review. Oh, here comes the neighbor's dog. It's legal to sign someone else's name as long as you have permission from them. Hey, Bobby with an eye. How are you doing today? Maybe she added something and added initials. All right. Before the court is defendant's motion to compel disclosure of Giglio material. I want to say Giglio. Giglio sounds more funner. Giglio. Through which the defendant requests an order compelling the state to disclose any and all correspondence, reports, notes, and witness statements connected to the investigation of the statements made by Lieutenant Hemingway to any members of the county attorney's office on January 24th, 2025. LT is lieutenant, right? For some reason, I thought lieutenant was a different abbreviation. I guess it is LT. Thought it had like 3 letters. Relating to whether a team of law enforcement officers working on Kouri Richins' case were aware that she was represented by counsel in April of 2023, and whether they were instructed by attorney from the county's attorney office to interview a suspect who they knew to be represented by counsel outside the presence of her counsel. Defendant's motion is based on and adopts by reference all the relevant facts in defendant's reply to the state's opposition to reopen evidence for a motion to suppress. I think the officer testified saying that, like, oh, I was new to the Kouri Richins case. I skimmed through the case file. I didn't really know too much, so I decided to go there and introduce myself and tell her who I was. And I didn't know that she was represented by counsel. All right. Defendant's motion is based on the defendant's concern regarding the veracity of Detective O'Driscoll's testimony that he was not aware that Kouri was represented by counsel when he performed the knock and talk interview of the defendant at her home on April 14, 2023. So this is the interview that the court has already made a ruling on about how she invited law enforcement into her house. She made these statements, and these statements were not protected under Fourth Amendment. Fourth Amendment? No, Fifth Amendment. Fifth Amendment, I think. Having reviewed the defendant's motion, the state's opposition brief, and defendant's reply brief, the court rules as follows. Defendant has not shown that the veracity of Detective O'Driscoll's testimony is relevant to her Fifth and Sixth Amendment arguments related to the statements she made during the April 14, 2023 knock and talk. Oh, sorry, Fifth and Sixth. First, defendant was not subjected to custodial interrogation on April 14, 2000. You're already home? Oh, wow. First, defendant was not subjected to custodial interrogation on April 14, 2023. Court already made that ruling. Because defendant's counsel only anticipatorily asserted her right to counsel outside the context of a custodial interrogation, the detectives did not violate the defendant's Fifth Amendment rights by interviewing her on April 14. Second, because judicial proceedings against the defendant had not commenced as of April 14, 2023. So again, we're echoing the same thing that was in the judge's order. Defendant's Sixth Amendment right to counsel has not yet attached. Accordingly, what Detective O'Driscoll and any other law enforcement knew or did not know regarding the defendant being represented by counsel as of April 14, 2023 does not implicate defendant's Fifth and Sixth Amendment rights. Further, defendant has received a copy of findings of facts that the state's outside counsel generated after investigating any possible inconsistencies involving Lieutenant Hemingway's and Detective O'Driscoll's reports. But defendant fails to make a showing or argument sufficient to support an inference that the state's outside counsel, or law enforcement working on this case have failed to produce exculpatory evidence, whether direct substantive evidence or impeachment evidence. For example, defendant does not point to any gaps or inconsistencies in the state's outside counsel's finding of fact or the state disclosure of them. However, defendant makes reference to various rules of professional conduct and argued at the February 21 hearing that violations of rule of professional conduct may require exclusion of evidence. But the defendant has not demonstrated any violation of any rule of professional conduct that has occurred relative to Detective O'Driscoll's testimony, or that such violation, if it did occur, would require exclusion of any statements made by Kouri Richins on April 14, 2023. The foregoing discussion weighs in favor of ruling that the defendant has not shown that the state or its agents have failed to produce information as required by the Due Process Clause or Rule 16 of Utah Rules of Criminal Procedure. But one remaining issue prevents the court from denying defendant's motion to compel in full. Dun dun. The notes generated by the state's outside counsel while performing her witness interviews. Where are these notes? The state asserts the state's outside counsel did not collect written witness statements or record witness interviews, and the defendant does not assert otherwise. But the state does acknowledge that its outside counsel took notes during her witness interviews. Give us the notes! Defendant reasonably asserts that those notes may contain purely factual statements regarding what any particular witness said. The court acknowledges that depending on their context, such as factual statements, may have some value as impeachment evidence. So we are going to ask for those notes from the state. Hopefully the state can get them and give them to the defendant, and then we'll figure out what the judge is going to decide. All right, here. Okay, that looks like it says bukkake right there, but it says butt take. But, you know, me just glancing over it. This is the walk the dog letter. The state wants to admit the first 3 pages. I think in total there was like 6 or 7 pages. They want to admit all 3 pages, and they want to redact this beginning part over here and redact this part over here. We actually have the entire walk the dog letter somewhere. Now let's talk about the state's motion to determine the admissibility of the walk the dog letter. Let me close my door real quick. Actually, I'm gonna use the bathroom really quick. Give me a second. Giglio is known witness with history of lying. Yeah, so they're trying to accuse the law enforcement of testifying on the stand, or on the hearing that they were lying about whether or not they knew Kouri Richins had legal representation. Take him. Shiro! We need to take sure to get his allergy shot. He's been licking his feet. Shiro! Hi, Shiro! Are you licking? Are you eating your feet, Shiro? I'm pretty sure it's a seasonal thing, like a environmental seasonal shit. Not something that he's eating, but we'll see. We'll take him to get your little allergy shot, Shiro. Shiro says hi, by the way. Amanda, hello! So many trials happening. I know. There's Karen Reed, there's Kouri Richins, Lori Vallow, round 2, but for a different murder charge. Got Donna Adelson, Ryan Koberger. There's a Minecraft Happy Meal. Oh, what kind of toys do you get? Do they look good? I don't know, man. I'm just disappointed with the whole McDonald's toys and shit. You know, back in my day when I was growing up as a kid, we used to get some really cool shit. And like the McDonald's Happy Meal or the Big Kids Meal. You guys remember like all the cool stuff you would get, like the McDonald's or like McDonald's like celebration cups, the glasses, or the little Beanie Baby toys, or like the Barbie toys, the Hot Wheels. They're such cool shit. And then now, remember how they tried doing the McDonald's Happy Meal cups? Dude, they fucking suck. They're like pieces of shit. It's plastic. You can't even run them in the dishwasher. You gotta hand wash them. Like, ain't nobody got time for that shit. I know, they're not good. So sad. We need to bring back the cool shit. Because initially, like the cups were cool. It was like, oh, there's like Beanie Babies on there. It was like Hello Kitty. But then when we got the cups, I'm like, yo, this is like a piece of shit cup. Not only is it plastic, and you can't even put that much water in there. It's dinky. Jollibee. Ooh, I just tried the sauce. Fudge that. Reminds me of the BTS spicy sauce. BTS the group. Jollibee in the Philippines had a Sanrio Ferris wheel toy set. Oh, it was pretty awesome. That sounds fun. That sounds really fun. Yeah, give me the cool shit. All right, so walk the dog letter. We want 3 pages. Honestly, I think we've already covered a lot of these arguments before in regards to the walk the dog letter. The state is saying that the walk the dog letter is authentic, that it was written by Kouri Richins, and she even admitted that she wrote the letter. The walk the dog letter is not hearsay. The walk the dog letter is relevant. The first 3 pages of the walk the dog letter are relevant because the defendant uses them to solicit false testimony, which reveals her consciousness of guilt. Prior to her arrest, the defendant consistently maintained to law enforcement the office of the Utah medical examiner and, the life insurance company that Eric did not use illicit drugs. I don't know how fentanyl got in his system. All I knew he did was that he did THC gummies. However, now she's trying to get her brother, it seems like, to testify that, there's a newfound unsupported theory, that Eric Richens obtained fentanyl from Mexico. Yep. We go to Mexico, get some fentanyl from there. Why solicit false testimony to support a fabricated defense unless you know you are guilty, says the state. Moreover, the first 3 pages are relevant because the defendant writes, in quotations, Eric, ... asked if Carmen could get him some pain pills and fentanyl. You mean the same Carmen that you, Kouri Richins, were communicating with? This corroborates the defendant's admission that she asked Carmen Lauber for pain pills, and that Carmen Lauber's statement, the defendant asked her for fentanyl. The defendant's consciousness of guilt, as well as corroboration, the defendant purchased fentanyl from Miss Lauber, tends to make it more probable the defendant poisoned Eric Richens with fentanyl. I was a little confused about this sentence here. A little confused. It's like, she probably tried to tie Carmen Lauber with Eric Richens, but I don't know if it directly shows her consciousness of guilt, and that there was corroboration that she purchased fentanyl from Carmen Lauber. I don't know. I guess the sentence really confused me. Let's read it again. Hold on. This corroborates the defendant's admission that she asked Carmen Lauber for pain pills. I don't know if it really does. But it would make sense, though, because she was the one who was in communications with Carmen Lauber, right? There was text messages between her and Carmen Lauber about getting the fentanyl, getting the Michael Jackson stuff. There was phone calls back and forth. Carmen Lauber ended up getting it from her drug dealer. And so I guess the state is trying to say that, now that in the walk the dog letter, she's trying to tie Eric Richens to Carmen Lauber somehow, then that would corroborate Kouri Richins' admission that she also got pain pills. I don't know. I'm still a little confused. She's a little confused. I don't know if I make the connection there. D, the walk the dog letter's probative value is not substantially outweighed by unfair prejudice. So it's going to talk about unfair prejudice and then versus the probative value, case law stuff. I thought this was interesting. Let me see if I can find it. This is just a little side tangent here. So unfair prejudice. Here's a case where the court deemed that it was unfair prejudice of presenting this type of evidence. The Jonestown member was tried for conspiracy to murder a congressman, among other charges. James Jones was the alleged member of the conspiracy. A federal district court held that playing the last hour tape contained probative statements about the conspiracy was inadmissible under Rule 403. The government appealed. Screams of dying children could be heard in the background of the probative statements. My God, can you imagine just listening to this fucking last hour tape? So sad. The relevant discussion was set against the background cacophony of innocent children who had already been given poison. We've heard the tape and agree with the district court with regard to the emotional impact and distracting effect. The tape would tend to divert the jury's attention from the issues in this case to a significant amount of extraneous matter. As a result, there would be a considerable potential for unfair prejudice and a confusion of the issue. Here's a different case. Here are the first 3 pages of the walk the dog letter are probative for the same reasons that they're irrelevant. Nothing about the first 3 pages is unfairly prejudicial. Soliciting false testimony does not appeal to the jury's sympathy, arouse its sense of horror, or provoke its instinct to punish. Indeed, it is difficult to get most people to even care about witness tampering. I don't know about that. The first 3 pages don't describe or delight in Eric Richens' death. Nobody forced or coerced the defendant to write the walk the dog letter. The defendant holds a master's degree. I didn't know this. I didn't know she had a master's degree. She holds a master's degree. She wrote the letter risking the likelihood that the sheriff's deputies would find it and recognize it for what it is. Any prejudice is entirely fair and well earned. Again, walk the dog letter is offered for non-character purposes. We're going to skip through that. All right, so the state wants to admit the first 3 pages of the walk the dog letter. Yeah, the fucking cold poisoning shit. Crazy. Jimmy Jones, a cyanide Kool-Aid guy, he killed his entire cult, almost 1,000 people. Yeah. Crazy. All right. State's motion to determine the admissibility of the Orange Notebook. Oh, okay. So now we're starting to learn more about this Orange Notebook and what's inside of it. Here's what we got here. Statement of relevant facts. So again, this Orange Notebook is also called the diary that she kept for over a year after Eric was found dead. Number 1, detective sees an orange notebook from Kouri's place of residence. Oh, let me sit up, I guess. Okay. Like when I stream, sometimes I just like slowly shrink down. Remind me, it's bad for my posture. Don't sit like that, Corgi. Hi, CMB. How are you doing today? Hello. How's it going? Thank you for joining us. We're covering Kouri Richins right now. Got lots of court docs to be covering, and we're learning more things. We're covering the orange notebook right now, which is kind of like her diary. All right, so they seized the orange notebook from her house. The first 5 pages of the orange notebook contained the defendant's handwritten journal detailing the events of March 3rd to the 4th, 2022, the night of Eric Richens' death, which is, I thought this orange notebook was just like her diary, but it seems like this was a notebook that was purchased for the purpose of detailing what Eric Richens was doing. I don't know. She was trying to figure out maybe how to poison him and how much she needed in order to get him to just keel over and die, you know? Because she was also accused of potentially attempting to poison him a couple weeks before during Valentine's Day. Argument. Orange Notebook is authentic. The Orange Notebook is, as the state claims, a journal written by Kouri Richins, where Richins admitted that she wrote the Orange Notebook. She admitted to it? Really? Moreover, the writing is in the defendant's handwriting, and the journal contains information that only the defendant would know. Man. Orange Notebook is non-hearsay. Orange Notebook is relevant. Now, here's what's relevant about it. The first 5 pages of the Orange Notebook are relevant because they provide the defendant's first-hand account of the night of Eric Richens' death. They contain certain details regarding timeline, the defendant's movements, and what Eric Richens consumed, among other relevant details. Why was she writing this down? Thus, these details, especially when compared with other evidence in the case, tend to make it more probable that a defendant poisoned Eric Richens with fentanyl. I gotta see this orange notebook. I gotta see what's in there. Oh man. All right. Again, it's gonna go into some other cases. It talks about the Jonestown poisoning, some other cases, and they are arguing again that first 5 pages of Orange Notebook are probative for the same reasons that they are relevant. None of the first 5 pages is unfairly prejudicial. Again, is an argument by the state. They do not appeal to the jury's sympathy, arouse to a sense of horror, provoke his instinct to punish. The first 5 pages do not describe or delight in Eric Richens' death. Nobody forced or coerced the defendant to write the Orange Notebook. She holds a master's degree, and then she journaled, risking the likelihood the detectives would find and recognize it for what it is. All right. So again, she's got a master's degree. All right, next one. State's motion to determine the admissibility of the April 14, 2023 interview transcript. Wait, what was this again? Interview transcript. Oh, I don't think this transcript is... Let's see what's in this transcript. I don't think we have a copy of this transcript. It's, let's see, redacted transcript. Oh, do we have a copy of this transcript? All right, so they want to admit the transcript with Detective O'Driscoll, April 14, 2023 interview. This was the interview that happened in her home. Detective O'Driscoll recorded this interview with a body cam. Is this the body cam? Okay, I could have sworn the defense accused Detective O'Driscoll of surreptitiously hiding this recording. I thought it was like a recording that they had. It was just audio recording, not a body cam thing. I could have sworn the defense was arguing that, saying like, oh, he came in the house, you know, and he was secretly recording everything. She didn't know. All right, so the interview transcript is authentic. Detective O'Driscoll, who's familiar with the defendant, has testified to the facts and circumstances surrounding the interview, including the defendant's identity. Moreover, the interview transcript contains detail regarding the night of Eric Richens' death that only a defendant would know. Oh, okay, so they must have talked to her for like an hour and a half where they're like, okay, well, tell us again what happened that night. You know, what did you observe? What did you do? How long did it take for you to call 911? Blah, blah, blah. The interview transcript is relevant because it provides the defendant's firsthand account of the night of Eric Richens' death and other facts, circumstances surrounding, I almost said circumcised, and other circumstances surrounding his death. It contains certain details regarding timeline, defendant's movements, and what Eric Richens consumed, among other relevant details. And then I think we learned that initially a lot of us thought that Eric Richens was given like a Moscow mule that may have had the fentanyl, but I think it is now the state's theory that it was actually a shot of something and that would have had the fentanyl. So like, cause I was like thinking like, if you're drinking a Moscow mule, you're like sipping on it either through a straw or you're like drinking it through the cup, you would taste something gross and like bittery, you know? It would just be like kind of nasty. But if you took it as a shot, that makes more sense because a shot, you know, you're usually just throwing it back really quickly. Unless you like to sip on your shots. Ooh, why would you do that? Oh, actually, hold on a second. This is really disgusting and gross, so be warned. I have a friend who will take a shot of liquor and just let it marinate and sit in his mouth because he thinks it's better that way. I don't know. Honestly, his explanation doesn't make sense. Because you know, mostly when they take shots, right? They take a shot and they have like something to wash it back with, like a pickleback or something, or soda or whatever the fuck it is. So my friend says that like he doesn't like the taste of liquor, but he thinks it goes down better if he just lets it sit in his mouth before he swallows. And he drinks tequila, so that's like even more doubly like bleh. I don't know, letting it sit in your mouth like that, like oh, so nasty. All right, what do we got here? The court may exclude relevant evidence if its probative value is substantially outweighed by the danger of one of the following unfair prejudice. One of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Again, this is open the door. The court may exclude relevant evidence. Again, it talks about other cases. It's going to talk about the same thing as all the other ones. Same thing. She interviewed with the detectives knowing the state could use her statements against her. She commented that she understood the detectives were investigating her and chose to proceed with the interview without her counsel present. Indeed, the defendant used the interview to attempt to redirect the investigation away from her. You know how her attorney called the day before and said that like, hey, you know, I represent Kouri Richins, blah, blah, blah. I wonder if she was like, you know what? It probably will look guilty if I don't talk to investigators. So I'm just going to make it seem like I have nothing to hide. I'm going to talk to them. I got this, you know, instead of calling her attorney and be like, hey, you know, I got fucking law enforcement in my fucking house right now. What do I do? Can you come in here? I don't want to talk to them without you. Oh boy. Oh boy. Next one. Motion for protective order. Greg White witness subpoena. Who is Greg White again? Greg White. Oh, Mr. White was an accountant for Kouri Richins. And I think Mr. Greg White says he has a wedding to go to. That's right. Can't testify on May 16 because his daughter's wedding is on that day. And then from May 22nd through the end of the trial, he's got an overseas trip that he's already scheduled and he paid for long before the state served him the subpoena. Yeah, we are entering in vacation season. So these people are like, I don't want to testify. The state, however, is like, nope, get his ass to testify. I think Mr. Greg Wright tried to assert some like accountant client privilege. However, the state said that Utah does not recognize accountant testimonial privilege. So get him over here, get him to testify. But like he's got a daughter's wedding and he's got vacation that he already planned. Next one. Is this the long one? Oh, okay. So this is the one where we start getting to some of the details that the state has on Kouri Richins and some of the theories. Before I get this one, because I think we're going to end with this one. This one's fucking crazy. Okay, before we get into the crazy, let's get into the easy shit. Marie Bramwell was an attorney that I think I think this was an attorney that Kouri Richins tried to hire for divorce. Marie Bramwell does not want to testify, says that there's privilege under attorney-client privilege, blah, blah, blah. Then also, Marie Bramwell also has a trip out of state, previously planned, from May 17th to May 25th, and has already been purchased and has been scheduled for approximately 5 months. So she also got some vacation plans. She's like, I don't want to be there to testify. Well, you will learn more about Marie Bramwell in the other court doc. Okay, so this is like a very long thing, which I'm not covering. This is fucking 80 pages. But if you guys want to read it, feel free. Essentially, this was an expert hired by the state. And this guy is going to send out some questionnaires or something like that and analyze whether or not uh, whether or not the defense should be granted. Because I think Kouri Richins wanted to either move the trial into a different district or no, keep the trial in the same district, but then get the jury pool from a different county, I think, because she's scared of, of the current jury pool knowing about this case. However, this guy does like his extensive research, questionnaires. Here are some answers from the people that were surveyed, and it seems like they're probably able to get a, let's see, expanding the criteria further to include those who are aware of and familiar with one or both of Richens' case, but have mostly uninformed opinion, and applying these criteria for the designation of the likely impartial juror of the total of 1,500 potential jurors to be summoned. The Y2 Analytics survey data suggests that another 25% or a total of 65% of the jury pool would likely qualify as likely impartial. 65% of 1,500 results in 975 likely impartial jurors, or approximately 81 times the number of jurors to be seated for the trial. So I think this is like the state basically saying like, hey, we have this expert witness and we should just do what we're doing currently, which is not getting the jury pool from a different county. Because I think they did that for, was that for Karen Reed where they brought, no, or was that Richard Allen? Fuck, there's so many cases I'm getting all mixed up. I think it was Richard Allen. I think they got the jury from a different county that was like maybe like an hour or two away for the Richard Allen case. But there's that. And this is just some declarations, which I don't think we need to read any of this. All right. Let's get into some of the crazy shit. What do we have here? In my younger days, it was a thing, but I never savored it. I just did the salt. Yes, right? Salt and lime. Yeah. Who lets it linger and marinate in their fucking mouth? It's so gross. LOL. All right. So, last document of today. But, some crazy shit in here. States reply in support of its first notice of intent to offer Rule 404B evidence. Dun, 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 dun. The defendant's response to the state's first notice of intent to offer Rule 404B evidence seeks clarification regarding the notice. The state offers its reply to clarify the notice. So here are some clarifications. Case in chief, 404B evidence. Number 1, power of attorney and HELOC. Back in early 2019, Kouri Richins used a power of attorney to obtain a $250,000 home equity line of credit, the HELOC, on Eric Richens' premarital home. She used the HELOC to fund her new business, K. Richens Realty, LLC. Eric Richens first learned the HELOC in October 2020. I think when Eric Richens first learned about the HELOC, I think that's when he consulted with a divorce attorney and maybe like a wealth planning attorney. And I think that's when he changed the fuck, what was it? The Eric Richens Living Trust. I think initially the beneficiary was supposed to be Kouri Richins. Sorry. The beneficiaries are the kids, but I think the trustee was Kouri Richins. However, he changed it to his sister because I think he started to realize I can't fucking trust Kouri Richins. So I think that was the timeline. The origination and continued existence of the HELOC was a source of tension between the defendant and Eric Richins. The defendant informed Eric Richins that she would repay the loan and led Eric Richins to believe that she repaid it. Oh, well, contrary to the response, the HELOC was not paid off on the day of Eric Richens' death. It was actually overextended with a loan balance at approximately $254,000. So again, initial was $250, and it actually was never really paid off. She actually accrued $4,000 more. The evidence is relevant because it proves a pecuniary gain aggravator, so money, and the defendant's motive, intent, plan, absence of mistakes, and lack of accident in causing Eric Richens' death. Nicole! Hi, Nicole. How are you doing today? Hello, hello. Any prejudice associated with the defendant's breach of trust is not unfair because it involves the defendant's own conduct in connection with a charged offense. Any unfair prejudice does not substantially outweigh the probative value of the non-character evidence because the evidence proves unique motive. Not only did the defendant cause Eric Richens' death to repay the debt, but also to avoid confrontation with Eric Richens when he inevitably would learn that she had not repaid it. Yikes. Number 2, the affair. The defendant engaged in a long-term romantic affair with Josh Grossman. Mr. Grossman, I hope Mr. Grossman's not married out there. Dude, it'd be crazy if Josh Grossman was married and then his whole affair got like revealed because of these court docs. But I don't know anything about Josh Grossman. Mr. Grossman has referred to the relationship in his communications with the defendant as 6 years in duration, and the defendant did not correct him. So were they together for 6 years? That'd be fucking crazy. Because she and Eric Richens married, what was it, like 2012? 6 years is like, I think that's like half of their marriage right there, isn't it? Almost. The affair continued for approximately 9 months following Eric Richens' death. Yeah, after he died. The response's characterization of the affair as brief is inaccurate. The existing record contains daily, emotionally involved, intimate text messages between the defendant and Mr. Grossman, envisioning a future together without Eric Richens. I want to know more about this Grossman guy. The defendant made reservations for the two of them at, guys, it's called literally Secrets Resort. Look this shit up real quick. Secrets Resorts. Is this where you go to have your affairs? In St. Martin. Secrets Resorts. Dun dun. It's a Hyatt property. Bask in the sun on the beach by the infinity pool or an oceanside hot tub by day. And enjoy gourmet dining and world-class entertainment by night. Why is it called Secrets Resorts, though? It's all-inclusive. It's romantic. Adults-only resort located 3 miles from the airport. All right, guys. That's where you go to have affairs. Don't have an affair, please. Defendant made a reservation. She made a reservation for the two of them in resorts, secret resorts, before Eric's death for a date after Eric's death. So again, before Eric died, she made the reservation, and the reservation was for after Eric's death. Mere days after Eric Richens' death, the defendant, oh my goodness, texted Mr. Grossman a link to the romantic resort and said, "Are we there yet, girl?" These text messages are admissible under Rule 4, I'm using 404, Rules 801 through 803 as statements of a party opponent for the effect of the hearer and a present impression. The nature of the defendant's relationship with Mr. Grossman is relevant because it proves the defendant's motive, intent, plan, absence of mistake, and lack of accident in causing Eric Richens' death. Any unfair prejudice does not substantially outweigh the probative value of a non-character evidence because the evidence proves motive as old as time. Number 3, divorce consultation. Marie Bramwell. We are back to Marie Bramwell. This is the lady who said that she has a vacation during the time of the trial and it was planned 5 months out. Contrary to the response, the state neither noticed nor intends to admit any attorney-client communications between Kouri and Marie Bramwell. The defendant informed friends and family that she consulted Ms. Bramwell regarding divorce. Ms. Bramwell refunded the defendant's retainer in January 2022. The fact that the defendant considered divorce and rejected it in favor of causing Eric Richens' death is relevant, highly probative, because the premarital agreement provided that Kouri Richins would not gain access in C&E. C&E is Eric Richens' company if she and Eric Richens divorced, but would gain interest if Eric Richens died while married. Fucking crazy. The fact that people are like, you know what? Let's murder. Let's just do some good old murdering and then hopefully get their money. I just can't believe it. I don't know. I guess it's just the hubris of thinking that you're going to get away with it, assuming that she's guilty. Any unfair prejudice associated with the consulting a divorce attorney does not substantially outweigh the highly probative value of a non-character evidence. Federal income tax liability. Here we go. On the day of Eric Richens' death, Kouri Richins and Eric Richens' unpaid federal tax liability totaled over $300,000. Now, remember, from what the state says, the state said that, well, it's not like Eric Richens had this unpaid tax liability because he wasn't planning on fucking paying it. He actually thought he was paying it the entire time. The money was given, or the money was handled by Kouri. Kouri was supposed to use that money to pay off the tax liability for Eric Richens' company. Instead, she took that fucking money and then she used it to funnel into her own business, making Eric think that the taxes were paid for. That's what the state says. The unpaid tax liability resulted in part from the defendant's spending C&E, that's the company again, it's with Eric Richens and his business partner, tax distributions to Eric Richens instead of applying them to their tax obligations. The defendant was on the phone with the IRS for approximately 1 hour, 40 minutes the day before Eric Richens' death. I'm actually surprised that it was only an hour and 40 minutes. I feel like it would take an hour and 40 minutes to get the IRS on the phone, but maybe she has a direct number to them. This evidence. Hi, Emily C. Hello. Hello. Haven't called one of your lives before. Oh, hi, Emily. How are you doing today? Thanks for joining us. Everyone say hello to Emily C. First time for the live. They sure kept his name on the DL for a long. They did. They did. And then we started seeing the court documents, man. She was so pissed when she found the money was out of reach. Yeah, it's going to get into the fucking blowout that she had. The way they described her, I think she was like rocking herself and she was like having a panic attack and all types of crazy shit. Because she probably realized, like, fuck, I did all that for no reason. Huh. Eric is a couple steps ahead of me. Any unfair prejudice does not substantially outweigh the probative value of a non-character evidence because the evidence provides unique motive. Not only did Kouri cause Eric Richens' death to pay the tax liability, but to prevent Eric Richens from learning that she had diverted C&E's tax distributions and learning the extent of their outstanding non-dischargeable obligation. With this. Property tax liability. On the day of Eric Richens' death, Kouri Richins Realty, that's her business, unpaid property tax liability totaled over $10,000. This evidence is relevant because it proves a pecuniary gain aggravator and defendant's motive causing Eric Richins' death. Number 6, Navy Federal disarray. The disarray in Kouri's Navy Federal Credit Union account in the months leading up to Eric Richins' death is evidence of the defendant's overall financial distress and the desperate, unsuccessful measures that she was taking to forestall total financial collapse. Kouri must be so embarrassed about all of this just coming out into the public because here's the thing. When Kouri married Eric Richins, Kouri did mention that the family did not like her. Remember, I think Kouri Richins was like working at Home Depot when she met Eric Richins. Eric Richins was like a successful businessman, had his own business. You know, he fell in love with Kouri. And it seems like the parents didn't really approve of Kouri, but you know, Eric's gonna do whatever the fuck Eric's gonna do, right? He's a fucking adult. He can marry whoever the fuck he wants. Kouri said that on the day of the marriage or the day of the wedding, she was slapped with not literally slapped, but like the mother-in-law basically gave her this fucking prenup to sign. And she signed the prenup. And I think ever since then, she's been trying to prove that she's a successful business person, that she can make good money, and that I think she just wanted to prove the family wrong. However, when she started getting into this business and she realized that she was fucking shit up, you know, instead of owning it, she would borrow money to pay off old loans. She would take money from others to pay off loans. And it was just this endless, vicious cycle of all this interest accruing. And, you know, she couldn't keep up. She couldn't keep up. And that's why she was, you know, ultimately, it seems like she just started stealing money from her husband and her husband's business and to try to pay off all these like debt that she had. And like, in order to make it seem like she was a successful business person. Because I think at the end of the day, she didn't want to admit to her husband. She didn't want to admit to her husband's family that she failed. Right. But here's the thing. There's nothing wrong with failing. I mean, for Kouri Richins, it sucks because, yeah, you're going to be in a lot of fucking debt. But, you know, it's like a learning. You learn from your mistakes, right? And for Kouri Richins, financially, it was a very expensive learning course. What am I trying to say? Learning course maybe? But here's the thing. Kouri Richins, I don't think she learned shit. So what was she learning from her mistakes? I don't think so. I think she was just trying to see how long she could keep her business afloat for. Fucking crazy. All right. Number 6, Navy Federal disarray. So again, talks about her financial distress, the desperation. She was unsuccessful. She was trying to forestall a total financial collapse. Evidence is relevant because it proves a pecuniary gain. It's hard to imagine how any unfair prejudice. Oh my God. Okay, so we're going to take some jabs at Kouri Richins here. Well, not we, but the state. It is hard to imagine how unfair prejudice arising from bouncing 7 checks could substantially outweigh the probative value of this evidence. Contrary to the response, the jury can decide the weight of the evidence and whether the defendant's banking disarray is mitigating or supports the pecuniary gain element. AFCU disarray. American First Credit Union account in the months leading up to Eric Richens' death is evidence of defendant's overall financial distress and desperate, unsuccessful measures she was taking to forestall total financial collapse. Again, same thing that was mentioned with the other financial credit union accounts. litigation pressure. On the day of Eric Richens' death, the defendant was facing a lawsuit from Green Grass Holdings for breach of debt contract, and personal guarantee, seeking over $87,000 in damages. The defendant lacked the financial wherewithal to defend the lawsuit or repay the debt. Contrary to the response, the obligation remained unpaid on the day of Eric Richens' death. This evidence is relevant because it proves a pecuniary gain aggravator. Again, her motive, intent, plan, absence of mistake, lack of accident in causing Eric Richens' death. Lawsuit is highly probative despite the relatively small amount because it publicly revealed the defendant's financial distress, which contradicted the defendant's prized facade of success. It is hard to imagine how any unfair prejudice arising from a civil debt collection could substantially outweigh the probative value of the evidence. Beneficiary changes. This one I actually have not heard about. I did hear about her changing the beneficiary in the business partners and Eric Richens' like business insurance policy or something, and then I think they were notified and then they changed it back. But I don't know if this is the same thing or if this is a different incident. 2 months before Eric Richens' death, someone using the defendant's email address accessed C&E's online New York Life account and changed the beneficiary of Kouri Wright, again, that's Eric Richens' business partner, life insurance policy from Eric Richens to the defendant, and then back again. The defendant had access to the account. Kouri Wright did not access the account, and Eric Richens would not have known how to access the account. How would Kouri Richins know how to access the account, but Eric Richens wouldn't know how to access the account? I'm a little confused by that. Is it because she was running it or something? I don't know. Cam says, I feel bad for these people with these toxic spouses who are all about the money and looking for murder, looking to murder them for. It's so sad to be fooled by someone in a relationship. Talk about the ultimate betrayal. Yeah. Crazy. All for what? Money. Money, money, money. A jury could reasonably infer that the defendant accessed the account to change the beneficiary of Eric Richens' life insurance policy, realized that she had changed the beneficiary of the wrong policy, and then changed it back. This evidence is relevant because it proves a pecuniary gain aggravator. Chelsea Barney's house. Oh, is this the best friend? Chelsea Barney. Yes, I think this is the best friend. Oh my God, dude. It seems like she also tried to fuck over her best friend. I wonder if they're still best friends. In 2021, Kouri Richins Realty owned property at 299 East 100 South in Heber City, Utah, on which the defendant owed $456,500 in 4 short-term, high-interest, hard money loans. Again, these high-interest, hard money loans, short-term, they are not through like your traditional bank. Usually it's through it's not like going to the bank and getting these loans. These are through like, I guess they're kind of like loan sharks, essentially. But it's not uncommon for people to do this when they're flipping houses because they are planning on flipping the houses and selling the house within like a short time span and then getting their money back and then paying the, I call them money sharks or loan sharks. 3 of the 4 notes secured by the property matured on January 7 or 8, 2022. Beginning in October 2021, the defendant tried to refinance this property into a traditional 30-year mortgage. She planned to then sell or finance the property for her best friend. The best friend, her husband, 3 small children moved into the home. The defendant and her best friend signed a residential lease agreement with the option to purchase, wherein the best friend agreed to pay Kouri $2,900 per month in rent with an option to buy the home for $490,000. Again, Kouri Richins owed about $456,500. On January 11, oh, hey, Neko. Hello. Hi, LaDroid. How are you doing today? Very expensive lesson. Thank you. A very tough learning curve. Yes, thank you. Thank you. Hi, Neko. How are you doing today? How's it going? How have you been? On January 11, the best friend caused 2 wires totaling $45,000 to transfer into the defendant's KRR account. Correspondence between the defendant and her best friend established that this was a down payment intended for the long-term mortgage, supposedly closing on January 18, 2022. Oh boy, guys, get ready. Immediately prior to her best friend's wires entering the KRR account, the balance in the account was 1,996. Is that negative since it was in brackets like this? Negative, right? I don't know. As soon as the first wire entered the account, and before the second wire entered the account, the defendant transferred 19,299 of her best friend's down payment to her personal AFCU account to cover a wire transfer of exactly 19,299 to FundFi, a entity to which the defendant had taken out the high interest accounts receivable loan related to the property. By January 19, 2022, again, this is about the long-term mortgage was supposed to close on January 18, okay? But the day after, the defendant had entirely spent the remainder of her best friend's $45,000 down payment. On January 19, 2022, the KRR account balance was $226.69. Oh, yeah, so I think this is negative. Any accountants in the chat? The property refinance did not take place in January 2022. The defendant was forced to enter into an extension agreement with the largest of the four hard money lenders on January 26, 2022. The 30-year mortgage lender, so again, the house was supposed to be refinanced into a 30-year mortgage for the best friend. They revoked their proposal loan in mid-February and offered less affordable terms. Fuck, she fucked up so bad. The defendant was thus forced to enter into another extension agreement with the largest hard money lender on February 16, 2022. The unpaid principal balance on that date was $347,000. Okay, this looks like 347 million, but I think that's supposed to be a decimal right there. $347,715 and I think 86 cents. And the extension agreement extended the repayment term to March 8, 2022, 4 days after Eric Richens' death. Whew. The defendant's text messages with her best friend indicate that the $45,000 down payment consisted of her best friend's entire life savings. I wonder if she ever made this up to the friend. I would say no. Usually when people do fucked up shit like this with money and their families and their friends, like they get screwed over. I feel so sad for the best friend, but hopefully, I don't know, hopefully something good happened in her favor. By February 2022, the defendant's best friend down payment had disappeared into the Byzantine labyrinth of the defendant's finances. Hi, Thomas M. How are you doing today? Hello, Corgi in chat. Hi, Thomas. How's it going? Speaking of accounting, I gotta do my taxes. Yes, we gotta do this tax season. We gotta do our taxes, man. Although I did hear some people saying that they weren't going to do their taxes because maybe the IRS is understaffed this year. We'll see. But I would say still do your taxes. Follow the rules. By February 2022, down payment disappeared. Contrary to the response, this is far from a simple dispute between friends. Oh, they must not be friends anymore. Oh boy. Not only the defendant caused Eric Richens' death to pay notes on this property, but also to prevent her best friend from learning that she had squandered her best friend's entire life savings. Oh, she must have got some money from Eric Richens. Actually, did she end up getting the life insurance policy money from Eric Richens' death? I don't know if she did. Huh. Mujer, I've caught up. Hello, Mujer. How are you doing today? How fast did you have it on? All right, Hayden Jeffs. Shortly before soliciting the Michael Jackson stuff and fentanyl from Carmen Lauber, the defendant solicited propofol and fentanyl from Hayden Jeffs. Mr. Jeffs refused to provide the drugs to the defendant. Is propofol, is that the one that's like in the balloons? Like you inhale the balloons and shit, or is that something else? Mr. Jeffs' girlfriend overheard that solicitation and refusal. The defendant's solicitation is admissible under rules 801 through 803. 1.75. The evidence is relevant because it makes it more likely the defendant solicited Ms. Lauber, which goes to the defendant's intent, plan, blah, blah. The evidence is highly probative because propofol is not a street drug. Michael Jackson died of propofol poisoning. Propofol. What is propofol again? Propofol. Hold on a second. I should know what propofol is. Propofol. Oh, okay. Anesthesia. Intravenous anesthetic used for procedural sedation. Oh, never mind. That's not the helium thing. I don't know. There was like these people that were inhaling the balloon stuff. What is that again? But it's not like I don't know what they're I think it's like a drug. I don't know. It was weird. So like I went to this party, right? And there was these people that were playing with the balloons. And I thought they were just doing like the funny high noise thing, but they were doing it for a very long time. And I was like, what are they doing? And then later on, Dennis was like, oh yeah, they're doing blah blah blah. And I was like, oh, I didn't know people do that. Is it I don't know, nitrous oxide? I don't know. It's some drug thing. I don't know. I think like you have to keep doing it in order to feel the high or some shit like that. I don't know. Anyways, propofol is not a street drug. Michael Jackson died of propofol poisoning. Eric Richens died of fentanyl poisoning. Cell phone deletions. You're trying to delete your comment, YouTube won't let you. I can delete for you. Which one? The picker has broken since 2016. Laughing gas? No, it was. I don't know what. I think it's something else. Like there's something else in there. Oh, poppers. Yeah. So what is poppers? Is poppers laughing gas? I don't know. They're doing poppers. That's what it's called. But I don't know what poppers is. All right. Now, cell phone deletions. Nearly all text messages and electronic data stored on the defendant's phone in the 2 months preceding Eric Richens' death and 2 weeks following his death has been deleted. This is only mass deletion found on the phone. The phone was password protected. A jury could reasonably infer the defendant caused the deletions. This evidence is relevant to show the defendant's consciousness of guilt. Telephone records indicate the defendant exchanged an unusually high number of text messages with Ms. Lauber during this time frame, particularly 3 days before the charge attempted ag murder. I think that's the attempted aggravated murder for the Valentine's Day one, where they think that she tried to poison with the egg sandwich. When Miss Lauber procured fentanyl for the defendant and 5 days before the charge. Oh, actually, the egg sandwiching was really funny because state says that it's possible Kouri Richins tried to poison Eric with an egg sandwich and learned that that was not enough fentanyl. So from that point on, she took it as a learning lesson to get more a higher dose of fentanyl to poison Eric with. Now, I remember the defense was like, well, it was an egg sandwich. Who eats egg sandwiches 2 hours after getting it? I mean, I wouldn't eat an egg sandwich. I might get stomach issues or something like that. So they're trying to say that like Eric Richens didn't eat the egg sandwich like 2 hours later, that he would have ate it like right then and there and he didn't feel sick right away or something like that. I don't know. I thought it was funny. I'm like, I mean, there are people that might eat an egg sandwich, hours later, especially when you're really busy and you're on the go. All right. Egg sandwich. Miss Lauber procured fentanyl for the defendant 5 days before the charge ag murder. When Miss Lauber again procured fentanyl for the defendant, it's hard to imagine how any unfair prejudice arising from deletion data could substantially overweigh the probative value of this evidence. 13. Defendant's reaction. Oh, here comes the reaction, y'all, to learning that the Willow Court home belonged to Eric Richens' living trust, and she was not the trustee. On the morning of Eric Richens' death, the defendant stated that she was going to sell the Willow Court home. 2 days after Eric Richens' death, Amy Richens, again, that's a sister of Eric Richens, informed the defendant that the Willow Court home and Eric's personal property were owned by the Eric Richens Living Trust, and that Katie Richens was a trustee. It says Amy Richens here, but I think it's supposed to say Katie Richens. Unless Katie and Amy, I don't know, maybe she goes by Katie and Amy, but it seems like there's an inconsistency here. This news so upset the defendant that she lost it and punched Amy Richens a couple of times. When Amy Richens went outside and called the cops, the defendant fell to the ground, completely broke, had a panic attack, rocked back and forth, and started screaming. The evidence is relevant because it shows the defendant believed that the home would become hers upon Eric Richens' death and how intensely the defendant needed ownership of the home. I wonder if the home was paid off and she was hoping to sell the home and then, use the proceeds to pay off some of her debts. But anyways, I think if she fought in court, though, I think she would have been able to have some ownership of the home because during the time that she lived there, I'm sure she paid for, the rent. This evidence goes to the defendant's motive, intent, all that stuff, causing Eric Richens' death. Any prejudice associated with how the defendant reacted to learning she did not possess the home without reference, the resulting assault conviction, is not unfair, and any unfair prejudice is not substantially outweighed by the highly probative value. The walk the dog letter, again, we've already have the arguments for that. Now moving on to the next section. The egg sandwich should sue for defamation. Rebuttal, impeachment, and reconsideration 404B evidence. Number 1, HELOC fraud. Defendant obtained the HELOC using a forged power of attorney. Defendant's fraud in connection with obtaining the HELOC could become admissible in rebuttal or impeachment if the defense were to portray the defendant as a successful business person, or should she elect to testify. It would then be relevant that she funded her business with fraudulently obtained loan secured by someone else's home. Well, I mean, technically it was like her marital home, but I guess like I think it was like Eric Richens' home before they married. But once they got married and she lived there, I mean, I would consider her marital home as well. That was overextended on the day of Eric Richens' death. KRR would not have operated as an ongoing concern for as long as it did, absent this and other frauds. Any prejudice would be fair in the event the defendant chooses to open the door to the evidence. I wonder what she used that money on. Like, how much she spent on? Maybe it was like making a web page design, maybe making a logo, taking photos for her website. Wonder what she used the money on. Moreover, the committing fraud does not demonstrate propensity to commit aggravated murder. If the defendant testifies, the evidence constitutes specific instance of conduct of Rule 608 permits on cross-examination to attack the witness's character for truthfulness. So again, they're not able to use this to show propensity to commit aggravated murder, but they're going to use it to basically attack her character witness, or sorry, her character, to attack her character for truthfulness. Iron Bridge fraud. The defendant used a forged bank statement and a false statement. Oh my goodness. Okay, this is the one where I think there's quite a few of them. Iron Bridge fraud, the boomerang fraud, the Excel fraud, the second Excel fraud. I think this is when the state discussed how Kouri Richins would take her husband's company bank account statements and then basically delete the name and the logo and put her logo and her account or her business on there instead to represent the like, oh, these are my balances. See, I have a high balance in my bank accounts. And then she was applying for these business loans. However, when these financial institutions, when they're looking at her credit score, they're like, dude, you got a nice account balance, but why is your credit score so fucking bad? She's like, oh, well, my husband, like, he fucked up some stuff and fucked up my credit. And then I think she also said that, oh, someone stole my social security number, fucked up my credit, just basically saying that it was not her. She doesn't have a low credit because of her. It's because of other people. All right. Let's talk about her mom. Lisa Darden home fraud. The defendant fraudulently transferred the title of her mother's home to her business account, KRR Realty, then fraudulently encumbered the home with a $135,000 loan. So I guess this is how people are like, hey, if I want to have a large sum of money, get the fucking HELOC. The defendant's fraud in connection with her mother's home would become admissible if the defendant were to testify. Tax distribution, dishonesty. If Kouri Richins were to testify, her dishonesty in connection with C&E's tax distribution, again, her husband's company, constitutes specific instances of conduct that Rule 608 permits in cross-examination to attack the witness's character for truthfulness. I feel like she has to testify. I feel like she's going to testify. Can't wait. Hopefully she does. First, advertising, dishonesty. She made false claims in advertising to prospective investors. Second, advertising, dishonesty. False advertising claims again to prospective investors. Third, fentanyl purchase. The defense has reserved all objections, connections with the defendant's March 9, 2022 fentanyl purchase. So that is all the court documents that we have so far on Kouri Richins. We got a lot of stuff here. If you guys are only here for halfway or towards the end, go. What? Oh no! What happened to my internet? Wait, press 1 in chat if you guys can see me. I feel like my YouTube just crashed. Weird. 1 in chat if you see me or hear me. That's so weird. I know. Get Eric Richens' sisters to testify. His family members. Oh, you guys can see me? 1. Okay. I don't know. It's weird. YouTube just completely crashed. Whew. All right. I would do a whole recap of everything, but I just don't fucking remember. I closed all the court stuff already. Let me see. I can do a mini recap. Actually, do I want to do a mini recap? No, I don't want to do a mini recap. It's too long. I think what I'll do, well, think about it. I'll either make a video. So I made a Brian Koberger video where I basically recap a lot of the court documents, and then I added photos to accompany it, and then some screenshots, some excerpts from the court documents. That way people can visually follow along as well. I might do it for this one. We'll see. Maybe I will. Maybe I will. I don't know. So for those of you guys who did not listen to the entirety of the stream, or if you're like kind of busy like multitasking as well, sometimes you miss some stuff, I might just do like a major recap video. I think we might possibly do that. We'll see. Yeah, I don't know. I think I will. We'll see what other court documents come out. I gotta see if there's anything out with Donna Adelson. There's like new court documents of like the Blake Lively shit. I'm like, oh my god, I haven't caught up with that yet. There's like so much stuff just coming out. But that is it for today. We covered and we are caught up with Kouri Richins. Kouri Richins' jury selection is going to begin, I think, April 22nd. Let's see. Kouri Richins, jury selection. Oh, I think they think that jury selection will take about a week. So hopefully we have jury selection on April 22nd, and then possibly April 28th, we're going to have a 4-week trial with Kouri Richins. I think Kouri Richins and Karen Reed's trial will happen at the same time. Because I think even though Karen Reed's jury selection has already started, they think it's going to take a while before they find a group of jury to be on this case. Whew. All right, you guys can see it. Okay, hi Tina, how are you doing today? Hello, hi Winter Sky. All right, you guys can hear me, you can see me. Good. So guys, we will keep an eye on all the stuff that's happening so far. Again, we are currently covering Kouri Richins. We are covering Idaho 4 murders with Brian Koberger. Definitely watch the latest video. All the stuff that's happening with that for you guys to be caught up. Donna Adelson, we're covering that as well. The Justin Baldoni Blake Lively, covering it when I can. It's just a lot of shit. And yeah, guys, I think we do have some other trials that are happening at the end of this year that I haven't really covered before. The one is with Greg Walsh, I think, Greg Walsh, who's accused of murdering his wife, Anna Walsh. And that guy has some really bad fucking search histories. It's probably one of the worst that I've seen so far. Okay, Lorino says not 3 7th, but the following Monday for Karen Reed to start. Really? Not the 7th. Wait, hold on. Not. Let me see. Ugh, I'm trying to pull up the calendar. Wait, so Lorino thinks it's going to be next Monday or the Monday after that? I don't know. Emily Baker said end of April. So I was like, oh, maybe it's going to happen when Kouri Richins has her trial. But yeah, I don't know. We're going to be a lot of trial stuff happening. Jesus, a lot of trial stuff. Oh, and then, and then Lori Vallow's opening statement next Monday. So I will see you guys next Monday for Lori Vallow's trial for opening statements. I want to listen to it with you guys. Really? They already have 10 jurors? Oh, wow. Oh. I wonder how many alternates are going to have this time. I kind of wish. So there was a judge. Oh, Shiro's right here. You guys can say hi to Shiro. Did you guys watch the other hearing that happened? It's in the Turtle Boy case. There's a different judge that's overseeing it, and not Judge Canoni. I kind of wish that judge was overseeing Karen Reed's case. He seems like on point. I believe how we're doing today. I think I have my sound notifications off right now. So thank God no one heard it. Blue, thank you so much for the 47 months. How are you? What's up? Hello. I did hear about 13 men and 3 women on the Lori Vallow jury. Yeah. I love that judge. Lol. Yeah, I was like, hold on a second. I like this judge. Can we get this judge? I mean, I know we're not going to get this judge, but I wish this judge was overseeing the Karen Reed case. I don't know. I'm just not a huge fan of Judge Canoni. She's weird. She's a weird one. She's a weird one. I don't know. I feel like she's like, you never know what she's going to do. I don't know. She's an oddball. But, oh well. Anyways, guys. Well, that's it for today. My throat is kind of like hurting a little bit for talking a lot. I appreciate you guys being here. Thank you so much for hanging out with me and covering this live. And yeah, guys, join the Discord if you guys haven't already. Have your notifications on. Have the notifications on for all so you guys know when I go live, when a new video comes out. And then, if you guys want to make sure you guys get your notifications, the Discord notifications always go out. So some people are like, oh, the YouTube notification didn't go out, blah, 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 blah. It's like, I don't know, man. get the Discord. That way you guys get the notification when I go live. And yeah. No, thank you guys. Thank you so much for hanging out. Jan, hello. Jan, thank you so much for the 76 months. How are you doing today? How's it going? Oh, Jan, I might adopt a Pomeranian. I submitted an application for this Pomeranian rescue. I'm super excited. I don't know. I hope we can get Shiro a Pomeranian friend. And I don't know, because I really want a cat, but Dennis is allergic and can't get a cat, so I'm sad. But we tried to get the corgi, but I think that was a scammer. So I posted this corgi in our Discord that was available because the owner is abandoning it, and they're like, we're moving to a house and we can't bring our dog with us. I don't know why, but they might be a scammer, so I'm not too sure. So I found this Pomeranian rescue, and I was like, I don't know, we'll see. There's some really cute ones out there. Get one of those like hairless cats, easy peasy. No, I hear that the sweat of those hairless cats, and then also the saliva. People are so allergic to that. It's not just like the hair, so I don't think it will work. But yeah, I wish I could get a cat. Cat seems really cool. But you know, Jan has a cat, so Jan, am I coming over to hang with your cat? All right, guys. Thank you so much for hanging out. I hope you guys have a good one. Take care. Watch the videos that we've been posted so far. If you guys want to be caught up with the Idaho 4 murders, Donna Adelson, and yeah, I think we will do a video on this one, basically just recapping all the information in the court documents, unless something else pops up and I don't have time to do it. So we'll see. Pomeranians are so cute. See, I just like Pomeranians because every time, like back then when we used to take Shiro to the dog park, Shiro always got along with Pomeranians. Pomeranians just have this like energy that he fucking loves. They do this thing where they like to dance in circles, and he's always like amused by them, and they always play and they always have fun. So a lot of the Pomeranians that we've met so far, he's always got along really well with them. So that's what I'm hoping for. I think if we get a corgi, not quite sure that we'll get along. I just feel like corgis just don't like each other. I don't know. There's something about just corgis. They're just like so weird with each other. Like a competition or something. I don't know. I don't know how it is with corgis. So I don't think we're gonna do corgi, but possibly a Pomeranian. We'll see. All right, guys. Have a good one. Take care. I appreciate you guys being here. Hit the subscribe button, like the stream, and all that good stuff. And yeah, that's it for today.